And all right, so at this point, I want to welcome everyone to the Joint Standing Committee on the Judiciary. This morning, we have a work session on LD 1950, which is an act to implement the recommendations of the Commission to create a plan to incorporate the probate courts into the judicial branch. But first we'll start with committee introductions. And so committee members, I'll just call on you as I see you on the screen and ask that you don't stop your video during the introductions because that scrambles everybody and I lose track of who I have called on. Thank you. Let's see, we'll start with you, Representative Newell.
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell, and I am the Passamaquoddy Tribal Representative.
Representative Hagan.
Hi there. Thank you, Madam Chair. I'm David Hagan, House District 101, Hampton and Newburgh.
Representative Libby.
Thank you, Madam Chair. My name is Laura Libby, and I am a state representative from District 64. I live in Auburn and represent part of Auburn in all of Minage. And if I could make a quick note to any folks viewing this, it was brought up that at times my camera is covered with a sticky note. And I would just note that as a homeschooling family, sometimes in order to not have another naked child on YouTube, my camera is covered with a sticky note, but I am here listening and paying attention unless my camera is off.
Thank you. Let's see, Representative Evangelos.
Thank you, Senator Carney, Madam Chair. And good morning, everyone. Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you. Representative Babbage.
Yes, good morning, everyone. My name is Christopher Babbage. I represent House District 8, which is most of the town of Kennebunk.
Representative Sheehan.
Thanks, Madam Chair, and welcome everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Representative Poirier.
Thank you, Madam Chair. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Moriarty.
Thank you, Madam Chair. Good morning, all. I'm Steve Moriarty from House District 45, which is Cumberland and part of Gray.
Representative Thorne.
Good morning. Thank you, Madam Chair. Good morning from Carmel. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and a portion of Etna. And thank you, Representative Libby. Now Sophie's barking doesn't seem so bad.
Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I proudly represent Senate District 18, which is northern Oxford County in two communities in Androscoggin.
Representative Reckitt.
I don't know how I accidentally erased a whole bunch of things this morning, so sorry to be a little tardy. Thanks for whoever helped me get in. Anyway, this is Lois Reckitt. I represent District 31, the ocean end of South Portland, where apparently the computer geniuses of the world do not reside. So anyway, good morning.
Representative Evangelos, I'm sorry, did I call on you? I've lost track of people. Yep. Okay, great. And so Co-Chair Harnett.
Thank you, Madam Chair. Good morning, colleagues and members of the public joining us today. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside.
Thank you. And I'm Senator Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And I want to welcome everyone to our work today. And so I'll open the work session on LD 1950. And actually, before we proceed, I want to introduce the legislative staff who helps the committee with our work. And that includes Janet Stocco, the OPLA analyst, who will be with us a lot today, Peggy Reinsch, who is also an OPLA analyst, and Susan Panett, our committee clerk. Thank you all. And Janet, you prepared really extensive and helpful information on LD 1950, would you like to go through actually, let me ask committee members. This is a very long bill. Janet gave us a lot of really helpful information. I know that we were busy in session yesterday, and we've had different amounts of time to familiarize ourselves with the material. Are there committee members who have specific requests for clarification of information? Not seeing specific requests. So Janet, do you want to go over your bill analysis? Thank
Sure.
you.
Is that big enough for people to read, or should I blow it up a little more?
A little bit more, please.
Okay, thanks.
Thank you.
Yep.
That's great.
Okay, so as you know, this bill implements the recommendations of the commission to create a plan to incorporate the probate courts into the judicial branch, which met over the interim. And the report link is here. And all of these hyperlinks, if you look on the electronic committee file, should bring you to those documents. If they don't, just let me know and I'll fix them. So currently, the main constitution in Article 6, Section 6 provides for the election of judges and registers of probate to 4-year terms. And it provides also that if there's a vacancy in the offices due to death, resignation, or otherwise, that the vacancy would be filled at the next November election. And in the meantime, the governor would be able to fill the vacancies by an appointment until the person would take office after the election in November. In 1967, as you heard on the presentation on the commission's report, the legislature passed what we then called resolves. We'd now call it a constitutional resolution, but it was what you would think of as a constitutional resolution that proposed to amend the Constitution of Maine to repeal this specific section of the Constitution, and that the language of that resolve stated that it would become effective at such time as the legislature by proper enactment shall establish a different probate court system with full-time judges. Later that year, the voters did vote in favor of that constitutional resolution. So Part A of the bill specifically states the legislature's intent that by enacting this legislation, if you choose to do so, it would trigger the repeal that was provided for in the resolve, because it would be enacting legislation to create a probate court system with full-time judges. As you'll see, that doesn't happen all at once though, but it would be the enactment of such legislation. So that's what the intent clause says in Part A. Hopefully this is helpful to you to understand why the bill ends up becoming so complex when it's written. So although the bill is intended to trigger the repeal of that provision of the Constitution, the commission did not recommend, and the bill does not provide for the removal from the office of any county probate court judge prior to the expiration of the term in which the judge was previously elected under the Constitution. So to avoid that result, the commission recommended a multi-year, multi-step process for establishing a new state probate court with full-time judges. So there are 3 parts other than Part A, which is the intent clause. So Part B of the bill is effective immediately. And you may wonder, why would that be effective immediately if I'm about to tell you that the state probate court would not start until January of next year? And the reason that has to be effective immediately if you want to move forward is to allow for the election of county registers of probate and for several county probate judges this year. So because that would have to happen this year, you need statutes authorizing their elections since the constitutional provision will go away. And it would also need to be effective immediately to authorize the governor to begin the process of appointing judges to the probate court. And those probate judges, as we will describe below, would begin on January 1st of 2023. But you wouldn't want to start the nomination and appointment process on January 1st, 2023 if they're supposed to be in office that day. Part C of the bill, which is effective January 1st, 2023, would take effect when the new state probate court begins operating in several counties. And then Part D of the bill would be effective January 1st, 2025, when all of the counties would finally transition over to become part of the state probate court. So in a little bit more lengthier summary, this is based on the summary that's on the bill itself. And then, as you'll see, I did provide a separate chart that tells you what each section of the bill is doing, because it's quite long and it would be easy to become confused about what it's doing. So I thought that the chart might help. But as a general overview, Parts D and E of the bill establish a state probate court within the judicial branch that's distinct from the district court and the superior court. So that was a question that was raised at the hearing. So it is completely distinct. It's a separate court, but it is a state court. So by January 1st of 2025, the state probate court will be staffed by 9 full-time judges who are appointed by the governor and confirmed by the legislature, including 1 judge that would be assigned to serve as the primary judge in each of 8 new probate court regions. And those probate court regions would be aligned with the state's 8 prosecutorial districts. Those are established in statute. It may be helpful to know that the judicial branch has also established 8 court regions, and they match those prosecutorial districts. So all of those regions would match. So when the terms of the incumbent probate judges in Androscoggin, Franklin, Knox, and Penobscot counties expire this December 31st, they would be replaced by county probate court judges elected to 2-year terms that will expire on December 31st, 2024. And you'll see a little bit later in the bill analysis why that happens. It's to make the regions line up. But because the ballot qualification process has already commenced for those elections, Part B of the bill provides that the signatures collected by a candidate on a petition to qualify to appear on the primary or general election ballot for a county probate judge position that's established in the Constitution right now in one of these counties would be deemed to be a signature collected for that candidate to appear on the primary or general election ballot for the 2-year probate court judge position that's established in the bill. So the bill is drafted in a way that it takes effect immediately to provide for the fact that the elections are taking place this year. So the next part of the summary says that when the terms of the incumbent probate judges in Cumberland, Hancock, and Washington counties, those are the other 3 counties where their terms expire this December 31st, they will be replaced by 4 new state probate court judges appointed by the governor and confirmed by the legislature in the same manner as district court judges and superior court judges are appointed and confirmed. And these 4 new state probate judges' terms will commence January 1st of next year. I highlighted any provision that has to do with fiscal information that's not in the bill currently because the fiscal note hasn't been drafted. So although not reflected in the text of the bill, the commission also recommended that these judges be supported by 1 new law clerk, 1 new judicial administrative assistant, and 4 new court marshals, or 1 court marshal per judge. That would also be effective when the judges start on January 1st of next year. And that would require the addition of appropriation section to the bill, establishing and funding those positions on an ongoing basis. In addition, beginning January 1st, when the 4 new state probate judges start, they'll preside over probate proceedings in Cumberland, Hancock, and Washington counties. So those are the 3 counties where the terms of the current elected judges expire this December 31st, and they will be replaced by state probate court judges instead of county ones. So that's where the state probate court will take place. And the remainder of the state's 16 counties will continue to be served by an elected county probate court judge. However, if a judicial vacancy occurs in a county probate court after January 1st, then the vacant position would not be filled, and jurisdiction over that county's probate court matters would be transferred to the new state probate court. And as you know, as I just mentioned, there are only 4 state probate court judges. So if vacancies occur in many counties, it may be the case that there isn't sufficient judicial coverage for those counties. So the bill provides that if the Chief Justice of the Supreme Judicial Court determines that the number of state probate court judges is insufficient to provide for the efficient administration of justice in all of the counties that are served by this new state probate court, then the Chief Justice can request the governor to appoint an additional state probate court judge. Again, the fiscal information isn't in the bill yet, but although not reflected in the text of the bill, to assure that funding is available for all of the new potential state judgeships as they arise, the commission also recommended that all 9 new state probate court judge positions be funded through general fund appropriations commencing January 1st, 2023, and that would allow those to be filled as needed. But again, that requires the amendment of the bill to add an appropriation section for that funding. So generally speaking, there'd be 4 state probate judges starting next January. They'd be covering 3 counties, and then there'd be a chief judge. And then when the remaining county probate judges' terms expire in December 31st in 2024, they would be replaced by the number of new state probate court judges necessary to achieve the full complement of 9 state probate court judges. So probably 5 new judges, unless for some reason there was a need to appoint an additional judge in the interim. This should have been highlighted, although not reflected in the text of the bill. The commission also recommended that these new judges be supported by a second law clerk and judicial administrative assistant, and by 5 additional court marshals. Oh, this is why it's not highlighted. I'm getting ahead of myself. Because those positions will not be created in January 1st, 2025, however, which is after the end of the current biennium, funding for these positions does not need to be added through appropriations section to the bill, but it is important that you know that funding would be needed for those positions after the biennium. In addition, because the new court would start January 1st, 2023. The commission also recommended that the judicial branch be authorized to hire an information technology specialist and a facilities manager as soon as possible, and that general fund appropriations be provided for that purpose to help the judicial branch prepare for the establishment of the new probate court. So you'd need to add appropriations for that purpose. So why did the commission recommend certain judges, certain counties be filled and certain not? This chart is supposed to help you understand that. So if you look on the left-hand side, it tells you what will be the probate court regions. This also matches the current judicial branch court regions and the state's prosecutorial districts. And as you can see, for example, in York County, the term of the current probate court judge ends in December 31st, 2024. So under the proposal from the commission that's set forth in the bill, that county would not become part of the state probate court until January 2025, because this judge who was elected to a 4-year term would be allowed to continue and finish the term of office to which they were elected. But in all of the shaded counties here on the left, those judges' terms are set to expire this December 31st. And in order to not have regions that are somewhat state probate court and somewhat county probate court, what the commission recommended was that in Region 2, which is Cumberland County, because all of that region's judges, there's only 1, will expire December 31st of this year, that it would become part of the new state probate court next January. Similarly, Hancock and Washington County, which are in what is now State Prosecutorial District 7, their terms expire this December, so they would also become part of the state probate court January 1st of next year. But in Knox, Penobscot, Androscoggin, and Franklin counties, they're part of court regions where some of the terms expire this fall and some do not. So what the commission recommended was that in those 4 counties, you would elect a probate judge for a 2-year term so that their term would end along with this at the same time as the other judges in their region. And then all of that region could become part of the state probate court in January of 2025. So that's the plan. And if you see here where it says to elect a county judge to a 2-year term, that would be by statute under the bill, as opposed to the Constitution, which right now is controlling those elections because it's still in effect. And those are constitutional 4-year terms. So that's why when you look at the bill text, you'll see a large transition provision in Part B. And that's talking about the fact that if you're a candidate and you're going to be on a primary in one of these elections for one of these counties, all the paperwork you're filling out now would be deemed to be paperwork for this 2-year term so that those elections can continue undisrupted. Well, that's the goal of the way the bill is drafted.
Janet, can we take a little pause here for questions about the transition plan? Because this is a very complicated part of the bill, something that the commission worked really hard to make sure we got right, and that you personally, Janet, worked really hard to ensure that the transition would happen smoothly. And so I think there might be questions about it. And I do see that Representative Thorne has a question. Are you okay taking questions at this point, Janet?
I just don't know if you think it's better to unshare my screen so you can see everyone.
Let's keep it up on this screen for just a moment, because I think that this is a great visual aid. Go ahead, Representative Thorne.
Thank you, Madam Chair. Bear with me putting my question together again. Only because my mindset is one of smaller government versus larger government, but yet at the same time, I understand that there's a current need for this extra because of the pandemic, that it has created this backlog. And it may not be the correct term, but there is no sunset on this, correct? This program would be permanent going forward. And I'm just trying to understand that if we're creating this, and thinking of Senator Baldacci's testimony that he provided in regards to this subject, that it was to catch up. And once everything's caught up, would we stay at these numbers still post-pandemic?
So I think that's an excellent point that I'm glad you asked, because I need to make that clear. So if the design of this bill is that if it is enacted, it would trigger the repeal of that constitutional provision. So there would no longer be a constitutional provision saying that judges and registers of probate are elected to 4-year terms and how the vacancies are filled. It doesn't mean you couldn't go back to a county probate court system if in the future people figured out that that's what they desired, but all of that would have to be accomplished by statute because the constitutional provision would be repealed. And so moving forward, if the state probate court were retained, if this were enacted, the constitutional provision was repealed, this was set up, and it turns out people think having one judge in each of these regions, at least primarily assigned there, and a chief judge isn't enough judges, then the statutes could be amended to change the number of judges. If it's found to be too many judges, the statutes could be amended in any number of ways. It could reduce the number of state probate court judges, or alternatively, the legislature could decide, well, we want to have at least that many, but maybe they're not completely booked in their time. So we will allow them to be cross-assigned as possible to the other courts. There's a lot of different ways that could be tweaked going forward, but what wouldn't happen is you couldn't reinstate the constitutional provision. Once the repeal is triggered, that is done. It doesn't mean you can't go back to that system, but it wouldn't be under the Constitution unless there's a new constitutional resolution proposed and the amendments voted on, and that becomes part of the Constitution again in the future. Does that answer your question?
Is it my understanding that that's the simplest method to go about this versus having a sunset or something, a date to readdress and evaluate this situation in 4 years or 6 years versus putting it in statute and then having to introduce legislation down the road to repeal it?
So it would be difficult to put a sunset date in because, as I said, you're repealing the constitutional provision. So if you put a sunset date on this, what would it go back to? So, but there is a built-in process. I don't know if it satisfies you, if you'd want to change it in any way, but there is a built-in process for review 3 years after in the third year of the full state court taking over, and there's that process could trigger legislation, but it would have to be legislation to change it because it's now going to all be in statute, and you then have to go back and look at the statute to say, how do we want to change it?
Okay, thank you. Thank you, Madam Chair.
You're welcome. Senator Keim, go ahead with your question.
Thank you. I noticed that the bill is an emergency, and thank you for, first of all, Janet, this is an amazing overview. I really appreciate the work you put into this. And I noticed the bill is an emergency and understand that, then this has to be a 2/3 vote on this. And seeing it laid out like this, I understand why. I guess one of the questions I had, and I'm just as we continue to go through it, I was trying to remember if we talked about, and you said we have to get, this scored basically to figure out how much it's going to cost. But I thought we had talked a little bit about costs. The commission had, and that, is there some idea on how much this might be costing?
So we do have a memo from the Maine Commission on Indigent Legal Services. And that's just about the attorney appointment costs.
Okay.
Julie Finn from the judicial branch is in the attendee room, and at least when I checked before I started sharing my screen, and I know that they're working furiously on trying to figure out the costs to the state. What the commission did looked at a figure about the potential state judge costs, and then some potential costs for the court clerks and marshals. And I can link to that information on the commission's website, but I didn't do that because I thought, as the bill was being drafted and I thought more about what might happen with costs, there's facility costs, there's a lot of other costs that are tied to the judicial branch, and I didn't want to link to a misleading figure that was used for discussion purposes over the summer. I know that they're trying to get together an actual full figure and really looking at all the details. So
that's what I was thinking of. Yeah, I think that's what I was thinking of, is that there was some sort of discussion cost that that had been kind of thrown around as this was being, as the bill was being discussed in the commission. And then, so two other questions, which maybe you're going to get to later. So I'm just going to throw them out there. And if you're going to cover it later, then go ahead. One of them was about facility costs. I just wanted to know, so if these judges now serve they're paid for by the county, so then also the court is paid for by the county. So if we switch them to the state, then does the state take on what sort of facility cost? And then the registrars, are we also going to talk about registrars in here as well? And what the process is? Okay, great. Thank you.
And Senator Keim, I also did want to point out that Appendix I talks about the estimates of state court trial judge and justices and anticipated technology costs. It's not the detail that we expect to see in the future, but it's some information. Representative Hagan?
Thank you, Madam Chair. Just a quick one. Did I see I'm trying to remember, and I don't have it in front of me. Did I see a $2.5 million per year cost on this one somewhere?
So there's a $2.1 million estimate cost for the Maine Commission on Indigent Legal Services for taking over the costs of court-appointed attorneys in probate cases. And the assumptions built into that are all laid out in their memo, which is linked here, and it's also on the electronic committee file. But that's only one piece of it. Then there would be the cost of the state judges and the cost, as Senator Keim alluded to, of renting the facilities from the county for the courtrooms, and then all the staff, the law clerks and everything else. And that would be cost to the state. The counties would be alleviated of their costs of the judges, and to the extent they get leases from the state, they would receive some income for renting out those courtrooms if they choose to do so. But it's not an equal figure. I think it's a plus cost to the state for sure. We just don't know the precise numbers yet.
Thank you.
Committee members, any other questions about the transition aspect of this legislation? Not seeing any hands up. Thank you, Janet, for taking our questions.
No problem. Okay, so where were we? Okay, so Part B, C, and D of the bill, so all different effective dates, direct the Chief Justice of the Supreme Judicial Court to designate one of the appointed state probate court judges to serve as the Chief Judge of the probate court, and the Chief Judge would be charged with fulfilling administrative duties that are similar to the administrative duties of the Chief Justice of the Superior Court and the Chief Judge of the District Court. Those duties include facilitating the transition from the county probate court system to the state probate court system, and creating a statewide probate court schedule, ensuring uniformity of court processes and procedures, and ensuring that emergency matters are prioritized and addressed expediently, as well as securing and ensuring the accessibility and safety of probate court facilities, and preparing annual reports on the business of the state probate court. Part C and D of the bill direct that the state probate court proceedings be held in existing county probate court facilities if possible. And to accomplish that, it requires the chief judge of the probate court to negotiate leases, contracts, or other arrangements between the counties and the judicial branch regarding the use of those facilities. When necessary, the state district court and superior court facilities can also be used for probate court proceedings under the bill. Although not reflected in the text of the bill, additional general fund appropriations would be required for facility rental costs in counties where the state probate court is established effective January 1st, 2023. There also will be additional funding perhaps needed for facility rental costs in the remaining counties January 1st, 2025. As you know, that's beyond the biennium, so it wouldn't be added as an appropriations to this bill, but it would be additional funding that would be necessary in the future. So I think that starts to get at Senator Khan's question, I hope. So another key recommendation from the commission, other than transitioning to a state probate court system with state probate court judges, another key recommendation was to preserve the county registries of probate and their staff. But as you remember, when you repeal the provision of the Constitution, that provision of the Constitution also provides for the election of county registers of probate. So Part B of the bill provides by statute for the election of county registers of probate under the same terms and conditions applicable to county register of probate elections under the constitutional provision currently. Because the ballot qualification process for those positions has also already commenced, Part B of the bill provides that any signatures collected by a candidate on a petition to qualify to appear on the ballot this year for register of probate position that's established under the Constitution, those signatures would count for the candidate to appear on the primary general election ballot for the same position, but as it's established by statute in the bill, if you decide to move forward with it. So these parts B, C, and D of the bill also provide that as each county transitions to the state probate court, the county should continue to retain all of the fees filed in the state probate court proceedings in that county to offset the costs of maintaining its county registry of probate and of paying its registry staff. So those costs include, for example, the cost to maintain the current electronic case management system for probate court records that the commission recommended be retained during the multi-year transition to the new state probate court system. So the commission didn't recommend replacing that system. So again, that would stay as a county cost, and the probate court fees that the county currently receives, they would continue to receive even if their county becomes part of the state probate court, because they do still have the county staff and these other costs associated with the probate court registries. Are there questions about that registry provision or section? It's many provisions. Okay. So Part C of the bill under item 5 provides that beginning January 1st of next year, the Maine Commission on Indigent Legal Services would be responsible for paying and for establishing the minimum experience, training, and additional qualifications for attorneys appointed to represent indigent individuals at public expense in all state and county probate court proceedings. So again, that's going to be a cost that begins January 1st, 2023. So even though it's not in the bill now, that would be have to be funded through an appropriation section added to the bill. And that is the part of the cost that we do have information on. And that was the memo from the Maine Commission on Indigent Legal Services, which is linked below and is in the electronic committee file. So in addition to attorneys that are appointed in the probate court, the commission had some recommendations about court-appointed visitors, as well as guardians ad litem, who are appointed in state probate court proceedings, and that's item 6 of the summary. So these parts of the bill require the judicial branch to establish the minimum experience, training, and additional qualifications for court-appointed visitors in state probate court proceedings. So again, this is just in state probate court proceedings. Let me emphasize that the recommendation for court-appointed attorneys would apply to all court-appointed attorneys in probate court proceedings starting January 2023, regardless of whether that particular court is a county or a state court. As far as visitors are concerned and guardians ad litem, it's really focusing on the state probate court. So as something becomes part of the state probate court and part of the judicial branch, that's when the duties transfer to the judicial branch. So the judicial branch would establish all of the qualifications, minimum experience and training for any court-appointed visitor in a state probate court proceeding. And the judicial branch would pay the expenses of the court-appointed visitors and any court-appointed guardians ad litem that are in state probate court proceedings if the parties are indigent or the court is allowed or directed by law to pay those expenses. So again, because several of the counties would become part of the state probate court January 1st, 2023, there would need to be funding added to the bill through an appropriation section to help the judicial branch pay for the visitors and guardians ad litem in these state probate court proceedings. And then again, there's going to be a piece of additional expense that will happen in the future when the rest of the counties become part of the state probate court in 2025. There's going to be additional costs to pay for court-appointed visitors and guardians ad litem if they're at public expense, and that would be a future cost that would have to be funded in the future. Yes, Representative Rickett?
Yes,
Oh,
my
sorry.
question
Should I
actually,
defer to you, Senator Carney? I'm sorry. I just saw her hand.
yeah.
Go ahead. Thank you.
It's actually a question that arose in my head in your previous section of discussion, but my fingers weren't quick enough to get to the raising my hand, so I decided to wait. My understanding is that currently the chief judge of the district court and the superior court in the state are really have that title, have those duties, but they're assumed by a current district or superior court judge. And it seems to me it rotates sometimes, over, there's someone will serve for a few years as that and then decide they're going to let go of the chief judge thing and somebody else picks it up, but it's not a different judge. So my question is that likely to be the same in the probate system? You say there'll be a chief judge of the probate court. Will it likely be one of the existing probate court judges who will take on that responsibility and perhaps be compensated for it or not? I don't know.
So I do have familiarity. I did used to work for the chief judge of the district court, so I understand the system you're talking about. And the way that the bill is drafted, it requires the chief justice of the Supreme Court. So at this point, Justice Stanfill would have to appoint or designate one of the governors appointed in the legislature's confirmed state probate judges to be the chief judge. So it wouldn't be any other judge. It would have to be one of the probate court judges for the state. And the statutes in the bill that would establish the chief judge duties are modeled on the statutes for the superior court and district court chief judges currently. So I would imagine that signals that that's what the legislature wants is a similar system, but it really would be up to the judicial branch to decide how much does the chief judge sit in court. I know that the chief justice of the superior court and the chief judge of the district court do sit in court still. They don't only do administrative duties. That's allowed under this bill for the chief judge of the probate court as well, but it really would be the judicial branch that decides the contours of that chief judge's role and how that works, just along with the statutory guidance. But there's a lot of flexibility there that the chief justice and that the chief judge of the probate court would work out.
Thank you.
Okay, so those were the attorneys. Important to remember. I know I said this before, but they're slightly different, so I just want to emphasize it. For the court-appointed attorneys to represent indigent individuals, those would be costs assumed statewide, whether it's a county probate court or a state probate court, beginning January 2023 for the Maine Commission on Indigent Legal Services. And then as far as visitors and guardians ad litem, those would be paid by the judicial branch, those costs, but only if they're for court-appointed visitors and guardians ad litem appointed at public expense and only in state probate court. The county would remain responsible for paying any court-appointed visitor or guardian ad litem in a county probate proceeding, just like they are under current law. So this next part in item 7 gets to, I think, Representative Thorne's question. So Part D of the bill establishes the commission to evaluate the incorporation of the probate court into the judicial branch. You don't have to call it that. I just tried to come up with a name. A 15-member study group composed of the same categories of members that were appointed to the commission that established these recommendations that led to this bill. So under Part D of the bill, it would direct this new commission to conduct a thorough review of the new state probate court system in calendar year 2027, which would be the third full year of operation statewide of the state probate court. And that review must include, but is not limited to, evaluating the number of state probate court judge positions and their support staff is appropriate or should be adjusted, evaluating whether the jurisdiction of the state probate court, district court, and superior court should be adjusted in any way to increase judicial efficiency and access to justice, to evaluate whether to authorize the assignment of state probate court judges to preside over district court or superior court dockets to the same extent that judges in the district court and justices in the superior court are currently available for cross assignments, to evaluate whether there should be any additional investments to enhance the compatibility of the probate court and the judicial branch electronic case management systems. I'll just pause there to mention that the summary of the bill mentioned earlier that the county probate court's case management system, the commission recommended maintaining that for now. So that was put on a future idea of deciding in the future if those case management systems should be merged, but it wouldn't occur during the transition. And then also the commission in 2027 would be directed to evaluate whether additional opportunities exist to advance toward the ultimate goal of fully incorporating the probate court system into the judicial branch. At the end of calendar year 2027, the commission would be required to submit a report, including its findings and recommendations that could include suggested legislation to present to this committee, and the committee would be authorized to report out legislation to the 133rd legislature. So I provided here a link to the electronic committee file and then gave you who testified for and against. I will note that in the testimony, several issues were raised. First, county probate courts, it was noted, deliver cost-effective regional services while allowing for differences among different regions of the state. Another point raised in the testimony was that Maine's current county probate court judges are competent, specially trained, and responsive to the needs and schedules in their counties. Others mentioned that proceedings in state courts have been delayed due to COVID-19, while the county probate courts have not experienced significant backlogs, which raised concerns for some people testifying that the state courts are not as efficient as county courts and that the backlog in the state system might negatively, impact the new state probate court that's contemplated by the bill. And concerns were also raised about the potential loss to counties of probate court fees, especially if the counties remain responsible for providing physical space for probate courts. So specifically with regard to this last concern, that might be a concern in the future or if the bill is amended, but I did just want to explain that under the current draft of the bill, the counties would retain probate court fees. And while the judicial branch would be directed to try and negotiate leases to obtain the physical space that's currently used in county probate courts, the bill doesn't contemplate that the counties would be forced to offer that space for free or to subsidize that cost, although they certainly could choose to do so. The bill contemplates that the judicial branch would negotiate a lease to pay for using that space. But the other concerns that were raised in testimony are definitely for you to consider, and whether that should mend the bill or lead to your vote on the bill. As far as technical issues, as I mentioned before, if something is highlighted in yellow above in the summary, that means it's a funding decision that was made by the commission. So it's reported to you in the summary, but it doesn't actually yet appear as funding in the bill. So the committee, if it chooses to move forward, could direct that the bill be amended to include that funding, and then the fiscal note would be prepared, an appropriation section would be prepared, it would be brought back to the committee, and you could decide if you like the way it looks to be part of your amendment. There's a missing word "or" on one page of the bill. That's easy enough to fix if you want to. There's one transition appearing at the end of the bill. That was a miscommunication between myself and the revisor's office. So I don't think it's necessary, and it could be stricken if you agree. That's explained in the chart a little bit better. And then another sort of more policy type issue. It's raised in the chart, but there wasn't room in the chart to write it all out. So I wrote it out here. This is a topic that was discussed quite a bit before the commission, and that is that under current law, there are several statutes that require the judge of the court, the county probate courts, to exercise some supervision or oversight over the county register of probate. And it wasn't clear to me in preparing this bill for you as a committee bill exactly which judge should be the judge providing that oversight moving forward. So I just highlighted the provisions of current law that talk about that oversight. It's in 3 different sections of the probate code. And I wasn't sure what this committee wanted to do with that. It wasn't clearly specified by the commission. Would you want the chief judge of the probate court to be the one who acts as sort of the oversight and telling the county commissioners, for example, that the person isn't capably filling their duties and might need to be replaced or not paid and then somebody else substituted in? Or would you want that to be the probate court judge that's assigned as the primary probate court judge in the relevant region? Or would you want it to be any probate court judge sitting in that county on whatever day? So the bill contemplates that one judge would be assigned, one state probate court judge. Once the whole state is part of the state probate court, one judge would be assigned to each region. They would primarily sit there. The bill does, however, give the chief judge of the probate court the authority to assign judges, so it may be more efficient to have a different person in to cover a vacation, for example. Would that person who's in there on that temporary time be exercising this oversight? So that part wasn't clear to me, and I wasn't sure how the committee wanted to proceed. So that would be helpful to clarify, so we could clarify it in the bill. And then the chart I'm talking about is the annotated version of the bill. I also had made this chart earlier, so I thought I might as well send it to you, because I made this chart when drafting the bill. So it's another chart that shows you, if you look at each recommendation of the commission, where would you find that in the bill? So that is also posted online, and you should have received a copy yesterday. And then there were several items that were presented during the commission's meetings that I thought you might want to look at if you're curious about some of these details. And so I wanted to provide you links to all of them. I'm not going to read through them now, but I thought they were things that seemed very important and helpful to the commission. So I thought they might be important and helpful to you. So those links are there. And again, the fiscal impact, we don't know yet. And the judicial branch did submit testimony and explain that they're in the process of preparing the estimate of the cost to the judicial branch of the proposal. But we do have Justin Andrus's submission about the costs of the MCILS portion of the bill.
Janet, can I ask you a question about Justin Andrus's memo? I recall that in the commission meetings, there was a lot of discussion about the assumptions he made about which cases would require representation, and that he was working with a much larger number that wasn't analyzed to look at which cases actually would need counsel. Is the memo that is linked in your bill analysis, has that been updated since he presented to the commission?
It is updated in the sense that this is a new memo with cost estimates, but it does have that same underlying assumption. And the reason I mentioned it wasn't to suggest he's wrong, but I did remember that this was a big discussion during the commission meetings, that there were some assumptions underlying it. I don't know if they're right or wrong. I don't work in this field, but they are ones that were debated during the commission meetings. So I thought I'd point that out. So in establishing this estimate, MCILS assumed that counsel would be assigned in every case that impacts a substantial liberty interest. So for example, in every single adult guardianship proceeding, MCILS is assuming that counsel would be appointed to represent the adult respondent. And they're assuming payment for that by MCILS, even though it is possible, I don't know how often, but it is possible that the respondent's estate would have sufficient assets to pay, and then it wouldn't be a public expense sort of a appointment. As you know, if we don't have a snow day tomorrow, you're having a work session on a bill that talks about what should the presumption be about appointing counsel to adult respondents in guardianship cases. Should it be presumption that you always appoint, or presumption that you don't appoint unless certain things happen? So as you know, this assumption is important, but it may not match what's currently happening. And I don't know if it would match what happens in the future. It somewhat depends on whether 480 is passed or other decisions that the legislature makes. But that assumption does underlie this memo.
Thank you.
Shall I stop sharing so you can see everyone?
Yeah, yes, thank you very much. And that was a really thorough analysis, Janet. It's we really appreciate all of the work that went into preparing it, as well as the attachments. So committee members, let's focus first. I know that we want to talk about the policy issues, but could we please focus first on issues that are more in the line of factual clarifications and understanding any aspect of the proposal, just clarifying any of that first. Okay, well, we do have one question. Go ahead, Representative Harnett.
Thank you, Madam Chair. Sorry, too many buttons. Thank you very much, Janet. That was a tremendous overview, and I may have missed it. And this question might be just based on ignorance in my part, but we're talking about setting up 8 districts that align with the judicial districts. So that gives us 8 judges. But we haven't, the bill calls for 9 judges. Yet you said that the presiding judge, or the one who would look over all the other judges, would come from that original number. What is the 9th judge?
So the bill sets up, the commission recommended really that there be 9 state probate court judges, with the idea that generally speaking, 1 judge would be assigned to each court region and the 9th would be the chief judge. But nothing in the bill requires that 1 judge or each individual judge who's not the chief only ever sit in that region. So if you look at the case statistics, there's a link to it here. If you estimate that 8 judges are needed, where would they go based on the caseload? And not every region is exactly 1 full-time equivalent worth if you just assume 8 is the right number of judges. So you might need more coverage in Cumberland County, for example, than you would need in the region that has Washington and Hancock counties. So the bill is written in a way that the chief judge of the probate court can say, okay, you judge who's normally assigned to the region with Cumberland County might have to sit, you might need some help on a few days. And so one of the judges in a less voluminous region might sit some of the time there, or maybe the chief judge themselves would go sit in Cumberland County some of the time to take on some of that caseload. Does that answer your question?
I'm still a little confused. The chief judge is not the 9th judge.
Yes,
it is the 9th. Okay, that answers my question. I apologize. Thank you.
Representative Moriarty.
Thank you, Madam Chair. Janet, this may be a question more for Julie Finn, but if you can handle it, that's fine. I note that the bill provides that the probate court in a rustic must hold sessions a minimum number of times at both Presque Isle and Holton. In looking at my map of prosecutorial District 8, there are also district court sites at Madawaska, Caribou, and Presque Isle. Oh, did I say that already? Madawaska, Presque Isle, and Holton. So my question is, does the probate court sit in 5 locations in Aroostook right now, or just 2?
I'm not exactly sure all the locations where the probate court sits now, but it's not under the bill. It's not going to be based on where the district court sits. It's going to be based on where the probate court facilities are. And there is a statute right now that requires the court to sit in the, I'm not being able to find it really quickly, in the 2 locations you mentioned, and that's by statute. And the commission said preserve that statutory requirement of where they sit in certain places a certain number of days per month in those counties. They didn't want to change that because the design from the commission was wherever county probate court judges sit now is where the state probate court judges will sit when they take over in that county. So match whatever it is.
Okay, actually, you'll find this on page 8 of the bill as printed, where they must sit twice a year in Fort Kent and four times a year in Caribou. And I just wondered whether the court meets also in the other communities of Madawaska, Presque Isle, and Fulton. My thinking is that if there is one judge for Aroostook, and there aren't that many locations, and they may not be that busy if they only have to go to Fort Kent twice a year, is that judge going to have enough to do?
So I just Googled it, and so if Google's right, the Aroostook County Probate Court is located in Holton. So they'll be in Holton other than the times where they're required to sit in Fort Kent and Caribou. But again, the judge is a state probate court judge, and Aroostook doesn't join the group until 2025, unless there's a vacancy earlier. So at that point, the whole state is part of the county probate court. And if there is a need for somebody in Washington County, maybe they would travel down to Washington County. Or if there's a need for somebody in Cumberland County, the chief judge could say, okay, Aroostook, you go sit in Washington, the Washington County person moves down, so that the person from Aroostook wouldn't necessarily have to drive all the way down to Cumberland County to sit in that court that day. That the bill provides flexibility for the chief judge to make those determinations, but there would, under the bill, have to be one of the judges would have to be assigned to primarily sit in Aroostook County. So there would be, the commission thought it was important that there be some regional knowledge of the judge in each county probate court or state probate court.
Madam Chair, one follow-up, if I may.
Go ahead.
Janet, I wonder if there was a strong feeling that the chief judge should not personally ride the circuit, so to speak. And again, I wonder whether there's enough for the chief judge to do if he or she is not sitting on the court regularly.
That's more of a policy question. I defer that to maybe Senator Carney or the people on the commission.
I'm happy to provide an answer to that question. So Representative Moriarty, the thought was that during the initial transition period, which would be about a 4.5-year period, that it would be important to have a chief judge who was really looking overall at implementation of the new state-based judicial branch probate court system, and that that chief judge would be very busy with helping with the transition, planning, figuring out a lot of the little details that are too kind of granular to include in the legislation, and really helping to incorporate and build up the expertise of the state-based probate court system. And that is why we also included in the legislation the review that will happen a couple of years after full implementation, so that all of those questions could be looked at. We may find that we need either fewer or more probate court judges. We might find that one judge could be, half assigned to a district and half assigned to being the chief judge. But we felt that during the initial transition period, there would be enough work and enough kind of system-wide issues that it would be important to have the chief judge be focused just on that.
Okay, thank you.
Yeah, and we also wanted to preserve and mirror the existing state court and prosecutorial district system, because it didn't seem like there was any need to create something that was in conflict with those two systems that are already working hand in hand.
Sure. Okay, thank you. Thank you.
Committee members, other questions about sort of understanding the proposal? Not seeing any hands up. Janet, I did want to ask you one question about the issues raised in testimony. I recall hearing, maybe not seeing in written testimony, but certainly hearing in Debbie Willis's oral testimony, her raising a concern about the uneven processes from probate court, county probate court to county probate court. She works for the Attorney General's office as the chief of child support enforcement. And I think that she said that she had kind of a statewide perspective on the probate courts. And if I recall, she raised some concerns about the consistency and quality of work, insofar as I think she even said that there was one probate judge who just refused to enter child support orders. Is that your recollection as well? I don't see it in the
Yes,
summary.
sorry, I must have been focused at that point on the testimony against. I didn't put in the issues raised in testimony 4. I apologize for that. But that was a concern that was raised. And there was also a lot of information brought to the commission, which I didn't put in because it wasn't in the testimony, about other concerns of why some other people supported the idea of switching to a state probate court system, about some inconsistencies of practice among different county probate courts, and then the perceived conflicts of interest. Nobody said that they saw an actual conflict, but there was a perception of conflicts of interest with judges who also practice part-time and might appear in an adjoining county in a probate court case. And so an attorney might 1 week be opposing the person who's then going to be the judge for them the next week for a different client, and the balance that requires the attorneys to strike, and how vociferously to argue their case and not want to annoy the person who's then going to adjudicate the case for a different client. So those kind of concerns were raised. I literally forgot, in focusing on making all these charts, to put any of those things in there. I apologize.
That's all right. Thank you for summarizing them now for the committee, because I do think that that's an important aspect of this proposal. It's an opportunity to eliminate a lot of those concerns. Senator Keim, go ahead with your question.
Thank you. I'm not sure if this question is for you, Janet, or for someone else that might be listening and in the waiting room, but along the lines of that question about not all of the probate judges sort of following the same process, is there a system of appeal if they're actually not following the law?
Sure, you can appeal to the Supreme Court, any case.
Okay.
The outcome of the case. And I guess you could file, I mean, you could ask others, but you could also file a disciplinary complaint, which I know has happened against judges in both state and county systems in the past for different reasons.
And if you did a disciplinary complaint, who does that go to, and who rules on that?
I'm a little rusty on that, so I might defer that. I believe it's the Supreme Judicial Court has supervisory authority over all judges in the state, but we would need to confirm that for sure.
Mm-hmm. So maybe if she's here, Debbie Willis would want to comment on whether she's ever made complaints about specifically about a probate judge to try to get something changed. I would like to know if that was something that was effective or not, and if there's some remedy out there that other than just changing the whole system, because obviously it's problematic not to have it work as it should and according to law, which is I think important as well. So yeah, so if there's someone listening that can comment on that with authority, I would appreciate it.
Yeah, and I will just volunteer that Debbie Willis is not here for the work session. She's actually out of the office until for several days, and so will not be able to answer that question today. Representative Harnett.
Thank you, Madam Chair. And this is a question for Janet that I've been asked. Could you explain the need for the emergency enactor? Again, given that it appears we'll know who's running for nomination for the positions before this bill by March 31st, and the bill will become effective well before the election, even without an emergency enactor. Can you just explain the need for the emergency? And then what would happen if the emergency needed to be stripped?
We're talking about, I don't actually know how many county registers positions are up this year, but there are county registers who are running for office. If you enact the system and it doesn't have the emergency, I don't know that it would have too much of an effect on the registers. I think it's more about the probate judges. So I'm going to pull up my chart so I don't misspeak which counties. So if the bill's enacted, the way that the constitutional resolve was written in 1967 is that the provision of the Constitution would be repealed upon the enactment of by the proper enactment of a different probate court system with full-time judges. So if the enactment of this bill triggers the repeal of that, then you don't have the constitutional provisions governing the election of the the county probate court judges in the 1, 2, 3, 4, 5, 6, 7 counties where their terms expire this fall. Some of them might have primary elections. And so if you don't have the emergency on it and you adjourn in April, then this bill becomes effective after the primary election has occurred. But in Cumberland, Hancock, and Washington, you aren't actually going to have an elected county probate judge this November because those will become part of the state court system. So I believe I was directed to put the emergency on, and I believe that the desire was to make sure that, or to avoid holding a primary election for a position that won't actually exist, because those 3 counties will no longer have a county probate court judge. If you don't put the emergency enactor on, it may be that anybody who's running right now in those 3 counties might say, well, I don't see the point of running anymore. And so there would be a very minimal election, but I think that was the point of the emergency enactor.
Thank you very much.
Yeah, thank you, Janet. That was a great explanation. Committee members, any other questions about the specifics of the proposal? I am not seeing any questions. And so at this point, I would like to open the floor up, so to speak, to a committee discussion about the policy issues and advocacy for or against the legislation. And so committee members, if you would like to speak for or against in anticipation of a committee vote, please raise your hands. Representative Evangelos?
Thank you, Madam Chair. When we last visited this bill, Ms. Willis assured me that the absorption into the court system was not going to create any structural problems, and I accepted that answer. And then we said that Ms. Julia Finn from the court system would report in to us on how she saw it. And that's my only remaining reservation. So if we could hear from her at some point, I just wanted to see what problems, if any, she foresaw. And also, I believe she was going to do a cost analysis if possible. So, and then I'd be willing to decide.
Thank you. And thank you so much for that reminder, Representative Evangelos. And we do have available in the attendee portion of the meeting, Julie Finn. And so I will bring her over to the panel and ask her to speak with us about the information that we requested in our earlier work session. Julie Finn, welcome back to the Judiciary Committee. And we appreciate your being here. And I know that we had asked you to provide us with some additional information.
Yes, thank you, committee, for inviting me in. I have been listening since you got started this morning. I think Janet, first of all, has done an absolutely amazing job on this bill analysis. This is so complicated. And I think responded accurately to some questions about the fiscal analysis, which we have a fairly extensive group that is working very hard on this and has been doing so for weeks. They started before the public hearing, before the bill was even drafted. I mean, we knew this was coming. We know you're very eager for the information and that it's going to be very important to the committee. And in fact, the group is working on it and we're fairly close. In anticipation of this work session today, I said, is there anything we can provide the committee? I know they're going to have questions. And the answer was not quite. But they are looking at this in so much detail in terms of the judge positions, the associated, clerk and marshal positions, the overhead for things like office space and furniture and computers, that sort of thing, assessing the cost of health benefits into the future. The tech pieces are very important. As you know, the probate courts have a different system. I believe it's called ICON. And I think the commission made a decision they would continue with that for the short term. So all of this is being, also they need to look at interpreters, printing, technology, supplies. I mean, every detail is being considered. And I really hope to have this for you soon. I wish I could have had it today, but it's just not quite ready yet. And we really want it to be a product that the legislature can really rely on, as in this is what it is really going to cost to do this. As you know, it's a complicated sort of merging. The superior courts and the probate courts do share space in many counties, and that's being taken into account as well. I think Representative Evangelos was also asking about how we would handle this in light of other demands and concerns right now, specifically some of the backlogs that we've been facing as a result of the pandemic. And the answer is, I think we'll do the best we can. Some of these dockets are not connected. So, and we were going to ask for appropriate positions to be able to handle this new work. So for example, if there's, a backlog in the, there is a backlog, we know that in the criminal docket and in small claims and in some other civil dockets as well. Well, really doesn't have anything to do with the probate work. And we're not going to have a lot of cross fertilization, for lack of a better term, in terms of staff. Also, we're going to try to develop some new positions to work specifically with the probate court people. Where there are efficiencies to be had, we'll certainly try to do that. But we will, if this bill is to pass and is funded, we will make it happen. I mean, it won't be easy. It wouldn't be easy at any time, honestly, but we'll do it. If that's the statute and that's the will of the legislature, we will do that.
Thank you very much, Julie. And I know that there are going to be some other committee questions for you. Senator Keim, go ahead.
Thank you, Ms. Finn. Thank you for being here. I am concerned a little bit about this. I guess that the court isn't maybe giving us a better idea overall on the ways they're going to address the backlog. And then to hear you come on today and say, we'll just take this on and we'll do it. And yet I'm not seeing the court moving forward with what is already under their purview, right? And I don't find good solid recommendations coming from the court saying, here's how we're going to handle the backlog, which is really concerning, the length of time that people are waiting to get finality to all of these issues. And then to say, I think without greater hesitancy that yes, we'll take it on and we'll do this too. I find that really concerning.
Well, a couple things, Senator Keim. First, I just want to point out that you had requested some information on family law backlogs, and I am working on that, and I haven't forgotten about it, and we'll get that to you in the full committee. I think, well, our supplemental budget request, I think, addresses the ways in which we are planning to address the backlog. The Chief Justice has had some meetings with legislators and has talked about this. You know, the supplemental budget, our hearing date is a week from tomorrow. More will be discussed about it. But, you know, if we keep, you know, with our current staff and our current procedures, frankly, we were somewhat understaffed prior to the pandemic, and our whole way of doing business was to get a lot of people into rooms at the same time, which we can no longer do. And with the new technologies that we have, they're great in a lot of ways, but they are also more difficult in other ways. They're more time consuming. So the backlog is not going to be cut into with current resources. We're going to stay where we are. So in the supplemental budget, the judicial branch has asked for additional people to address the backlog. One of the pieces of that is a position called referees, which are retired judges, and they will be able to, on agreement of the parties, handle some family law matters outside of the court. So we're thinking outside the box on this, and because recognizing that the backlog needs to be addressed, and the caseloads are not going to get smaller. They're not getting bigger anymore, but in order to get them to be smaller and reduced and eliminated, we're going to need to have more people to address cases. And that is something we're working on, and we'll have more information for you on that.
Understood that there's this, you know, a bit of crossover, but it ties in very much with my overall concern with the courts, is just saying, oh, here's a whole lot more work that we're going to put on top of the courts at a moment when the courts are extremely behind already. And so that's why there's a crossover in my question there, because they obviously do tie in, right? And so the fiscal note that you give this committee needs to reflect the amount of staff that would have to take on a really substantial new portion of work, still sort of under one hat, so to speak. So, but thank you for that. I look forward very much to diving further into what the court sees as necessary to deal with the backlogs as well. So thank you for touching on that subject.
Thank you. And I also just want to point out, as I think we have been neutral on this proposal, you know, from day one. You know, combining the courts, it's really squarely a legislative decision. We have not advocated or discouraged it. So we've really tried to, you know, be Switzerland in this whole debate.
Just one more question, if I may, Madam Chair.
Go ahead.
So I just didn't know on the other question I had about just a remedy if there was a problem with the way a probate judge was conducting business in their court. Do you know anything about the process that would be undertaken to try to deal with that?
Well, as with any judge, there is a code of of ethics and responsibility for judges, and there is a board where those complaints are addressed. I mean, it's similar to the main board of bar overseers oversees all attorneys. There is a group on judicial responsibility that has a similar role with respect to any judge in Maine, and that would include probate judges.
Okay. Do you know how effective that is, or how often judges, go before this board?
I don't. I know it is managed by Cab Howard. I think he handles all those complaints. I actually don't know anything about their workload or any specifics.
Okay, thank you so much.
You're welcome.
Representative Evangelist, did you have a question for Julie Finn?
Sure. Thank you, Madam Chair. I just wanted to fill in a little bit on the blanks. I did address an inquiry to Ms. Willis regarding part of this, and she assured me that while some of what Ms. Finn's talking about, we'll be hearing from her later regarding any possible problems. Ms. Willis did assure me that although there would be a merger, that the probate courts would continue to operate on a segregated basis. And Ms. Willis said she didn't foresee any problems in that reference. I just wanted everybody to remember that she said that, because she was allaying my concerns about some of this. And she said, while there may be some unforeseen problems with this merger, as far as the functionality and day-to-day business goes, the probate court would continue to function on a segregated basis and would continue to function as is. I don't know if anyone else remembers her saying that, but that did allay some of my concerns. I just wanted to remind everyone of her answer. That's all.
Yeah, I would love to comment on that, Representative Evangelist, because, throughout the commission process, we were very careful to ensure that people had access to the probate court system to address both urgent needs and to make sure that probate court matters were handled by judges with expertise in probate law. I mean, under the current system of elected county probate judges, somebody could run for that position without having any expertise or experience in probate law. But so what the legislative proposal does is it maintains a separate and distinct probate court within the judicial branch that will be available to ensure that urgent things like adoptions and some guardianships and other urgent matters can be handled right away and are promoted and given priority on the dockets of those courts. It also requires that the judges appointed to be probate court judges have significant expertise in probate matters, so that those cases can be handled with the knowledge of the law and experience that's required. I mean, these probate court matters, especially guardianship and conservatorships, they are depriving Mainers of their personal liberty and of their property. And so those matters do need to be handled with the utmost care and expertise by judges who are available and full-time dedicated to acting in their role as neutral probate court judges. And that's really, for me anyway, the heart of this proposal.
Thank you for that. That's how I remember it as well. Thank you.
Committee members, are there other questions for Julie Finn? I am not seeing any. I'm going to send you back to the attendee part of the meeting, but we know you'll be listening and we hope that you'll be available because we may have other questions that arise as we go through our discussion.
I'll be here. Thank you.
Thank you. All right, committee members, does anybody wish to be heard on the matters, sort of the policy aspects of this legislative proposal? I am not seeing any hands up. I actually would like to continue to comment because I think that I'll continue with what I said before. I do, we have seen in the course of our work, particularly the work we've done on legislation that proposes amendments to guardianship laws, that the issues at stake in probate court matters are really high stakes. There are fundamental liberty and property rights. Someone who is subject to an involuntary guardianship proceeding risks losing all decision-making power over, many aspects of their lives. And similarly, somebody who's subject to a conservatorship proceeding loses the right to make decisions about their money and their property. And those are, fundamental constitutional rights that are set forth in the US and the Maine Constitution. And if we enact this legislation, we are, first of all, we are implementing an amendment to the Maine Constitution that the voters approved in 1967. And secondly, we are treating those fundamental property and liberty rights the same way we treat all other fundamental rights, for giving persons who are subject to losing those rights access to a judicial system that is comprised of appointed judges who are vetted, who are reviewed, who are subject to annual reappointment, who are available full-time, and who are supported by marshals for their own safety, but who are also supported by all of the resources they need to do the best job they can do. During the course of the commission process, we heard from judges that they don't have those resources. Some judges, stay up late at night doing research in order to issue written decisions. And other judges pay for research help out of their own pockets. But these judges don't have access to the law clerks that all other judges have that help them do the best job they can do for the Maine people. And I think we also heard that there are delays in receiving access to justice that are caused by the current system. Debbie Willis provided testimony that actually shocked me, that there's a probate judge who refuses to issue child support orders. We also heard from practitioners, and they obviously were in a difficult position, but practitioners who said that the quality of judging in the current elected probate judge system is uneven. We have exceptional judges, but we also have judges who people feel are not meeting their needs. And yet, because, I'll leave it at that. We have judges that are not meeting people's needs. And if we make this transition, finally, we will have a much better probate court system to defend the rights of Mainers who are at risk of losing two really fundamental constitutional protections. So I would urge everybody to support this measure and move it forward for consideration. Thank you. Representative Thorne, go ahead.
Thank you, Madam Chair. And I would ask in advance that the chair not counterpoint my upcoming statements if possible, only that I looked at this through the eyes of the taxpayers and looked at many points that I've heard throughout this morning, including an incomplete fiscal note. It's hard to make any decisions based on something that is incomplete, and the fiscal note is obviously incomplete. The fact that the judicial branch has neither advocated nor discouraged this proposal, this bill, that's kind of another red flag for me that they didn't call for it. The fact that none of these probate judge appointments will be able to alleviate the backlog in any other matter other than the probate. And then just from a conservative point of view, we're growing government again on the backs of the taxpayers. Does not sit with me. So therefore, I will not be in support of this bill. Thank you.
Senator Kime?
So I remain unsupportive of the bill, as I have been right along. And I think there is a remedy for some of the issues that Ms. Willis brought up. And I would be concerned to think that maybe those do get followed through. I think consistency is important. I think the biggest issue I see is the idea that some of our probate judges are also working as attorneys. I think that having them as full-time would be helpful. They are under-resourced. I believe they do need help in that regard, and maybe that's something the state should consider, is overall how to help them do their job more effectively. But overall, I see problems with a hodgepodge system of the registrar still being elected and the judges being appointed. And I also want to leave some judges in the hands of the people. I believe that they stay very connected to their constituencies this way. And they definitely are responsive to what's going on in their area. And if people don't, if they're elected and they don't maybe have all the expertise they need, I think there are others out there that can help them. I know they do now meet regularly and work to help one another. And, there could be training and other things if they felt they needed it to move forward and make sure that they're offering their people the best services possible. But I remain impressed that their agility has allowed them to be responsive even during the pandemic and keep their backlog to a minimum in comparison to the state courts. And so I can't imagine a time where I would be less likely to vote for this change. And when I'm looking at what's going on in the state courts versus what's going on in the probate courts, I have very little faith that they're going to take it on in the middle of such of really scrambling to figure out how to take on their own work as it is, to then hand them this extra enormous responsibility, even just to all the hiring they would need to do and to change the system now. Is really bad timing. And even if I thought the system needed to be changed, which I think it needs help, but not an overhaul. And I don't put a lot of weight in a vote that happened in 1967, because whatever the issues of the day were, they're clearly not the issues of the day now, because there is zero outcry about our probate courts. I do not have constituents coming to me saying, you've got to fix this. Every once in a while, there are issues I hear about, but nothing overwhelming. And this is an overwhelming response to what I see as very few complaints. So I will be leaving my vote as it was when I was on the commission, as not in favor of this change.
Senator Kime, could I just ask you a follow-up question or two? Because the constitutional amendment really does talk about the transition happening when there are full-time probate court judges. And you mentioned that you think having full-time judges would be helpful. Are you envisioning each county supporting one full-time probate court judge? So, or is there some other system that you envision for having the full-time probate court judges?
I without talking to the counties and the probate judges themselves and saying and asking them for an opinion on how to make that happen, I don't feel qualified to say that, because I know that the workload is different from county to county. So for them to take on the cost of someone who's part-time and then make them full-time, that seems a big ask and maybe not appropriate. So is there another solution out there rather than having, 8 full-time probate judges or whatever? I don't know. Or would there be, the possibility that I don't know. I don't want to come up with the possibilities that I think some other people might be able to come up with better than I.
Okay. Yeah, and I just wanted to point out that, that was the purpose of the commission, that we did go through this long process of looking at other states and hearing from the probate court judges and vetting. I think at one point we had at least 5, if not 7 different proposals for how to accomplish that. And we did work very hard to reach the one proposal that we thought was feasible and then to encompass it in this legislation. And I know that there are other policy differences that we have related to this proposal, but I did just want to see if there was any common ground on that issue of full-time judges, because I was happy to hear that you thought that was important. And I also think it's important because it addresses that kind of fundamental issue of an attorney, litigating a case in front of a probate court judge and then possibly the next afternoon being an adverse party to that probate court judge. And that's a really uncomfortable position, I'm sure, for both the judges and the attorneys. So I appreciate you emphasizing the importance of the full-time judge. Thank you. Representative Harnett, I think your hand was up next.
Thank you. Thank you, Madam Chair. Again, I know the discussion will continue, but to have it focused, I would like to make an ought to pass, a motion ought to pass on LD 1950 and speak to that motion briefly, if I might.
Let's see if there's a second, and then you may speak. Is there a second? Seconded by Representative Babbage. And you can go ahead, Representative Harnett. And hold on, Janet's waving her hand.
I'm assuming you mean ought to pass is amended by the fiscal note.
Yes, I do. Thank you. Thank you. So I changed that to an ought to pass as amended by the fiscal note. And I first want to, again, thank Janet for her analysis, but also to thank the commission for all of the work that they have done on this bill over the past summer. I believe in a unified court system. I believe that it should be funded by the general fund, and the probate courts are now funded on the back of property taxpayers. And I don't think that's an appropriate way to fund our judicial system. I think this bill would also lead to greater consistency in terms of the qualification for judges, the training of judges, and the day-to-day practice of those judges. This bill would also result in more direct oversight by the judiciary as it exists today, and would lessen what we heard about in terms of inconsistent practices that vary county by county based on the individual probate court judge. I also think, and this is something you discussed, Senator Carney, oftentimes we think of probate and we think about wills, but these courts deal with fundamental liberty interests of some of the most vulnerable members of our population. And I think they deserve the highest qualified judges with a rigor in terms of consistency and practice throughout the state. And lastly, I appreciate the fact that this bill does retain the local touch by continuing having registers in every county, each and every county, elected by those that are directly affected by this aspect of the court system. So for those reasons and many others stated in the report, which I believe to be very thorough and very well done, I will be voting ought to pass as amended. Thank you.
Thank you, Representative Harnett. Representative Babbage, is your hand up to speak as well?
Yes, Madam Chair. Thank you very much for recognizing me here. This bill has been a long time coming. I thank Representative Harnett for his comments. My thinking is much along the same way. I do not believe that pressures on funding should influence justice, the responsibility to meet justice. So taking their responsibilities from the counties and transferring it to the general fund of the state, I think is a healthy change. Yes, it was important to me that registers remain elected to maintain that regional knowledge and accountability. But you know, elected judges introduced the opportunity for fiefdoms to be established. And although I have to say that we have outstanding probate judges, and I think Senator Kimes' probate judge is an example of somebody who is extremely competent and has been helpful in this process, although maybe a little reluctant to engage in the end result that I am seeking here. But I wanted to say that I think the fact that we have a chief judge that will be so important in the implementation process, that we have the staggered introduction to, I think this process has been very well conceived by the task force. I think that the reevaluation that will happen in 2027, that is part of the legislation, I think is an outstanding piece of accountability that we will be very interested in. And I think the time is right. We establish policy. Is this a desirable goal? I think that's where I'll be putting my vote today. Yes, costs are a factor, and they'll be decided through the AFA process. But I just want to point out that when I was elected, when I was assigned to this committee 3 terms ago, Judge Donna Bailey was a part of this committee. And I thought at that time that she was in the right place at the right time as we examined this. And her contributions, along with Representative Cardone, became very, very important. And of course, I commend our current chair, Senator Carney, for her part in the task force and educating me and others as to where we're going with this process. So I feel the time is right to address this. When the referendum was passed in 1967, I was 2 months into college, not 18-year-old, not yet eligible to vote. But I think the direction, the policy direction of what was decided by the people of Maine at that time was an appropriate assessment of where we should be going. And now it's nice, perhaps a little late in my life, but now it's nice that we have the opportunity to fulfill what is an obligation to provide greater justice for families in Maine. And so I'm enthusiastically supporting the bill. I thank all those that made this happen to get us to this point, at least. Thank you, Madam Chair.
Thank you, Representative. Representative Reckitt, go ahead.
I'd like to speak on 3 aspects of this proposal. I too, I haven't been sitting on judiciary as long as Representative Babbage, but close. And it's now my 3rd term on the committee, and I've been looking with increased understanding over time of the probate court system, and have in fact taken the opportunity to meet with the probate court judges a couple of different times, which has been helpful to my understanding as well. I think that the fact that the possibility of and the probability of utilizing probate court judges in once they're established, we have full-time judges. If they are in jurisdictions where there is not a full-time load for a little bit of time, this process would enable them to be reassigned by their chief judge to hear cases in the district court. And I think that ultimately it's going to help us at least not accumulate a new backlog, 2 or 3 years from now. But I think it also may help with the current one. My second point is that my understanding is that in order to have an accurate fiscal note, it has to come from a bunch of different places and information. Yes, indeed, the court has to provide information, but they provide it to the section of our process. And I keep wanting to call it OPLA, and it's not OPLA, the OPEGA, I guess it is, who actually does the fiscal notes, that we have to give them what's the policy we want established. Then they can produce a fiscal note that will reflect the reality, not just of the court costs, but the up and down of the courts and the counties and all that stuff. And we don't know that information, in part because they're not willing to spend the inordinate amount of time it's going to take them to do that, or not time necessarily, but resources. We need to tell them what's the policy we want them to research and give us an appropriate and accurate fiscal note on. So that's an understanding that I have come to on this bill more than any other, that the process has to be, we do the policy, they tell us the cost. And then we're going to look as individual legislators about whether or not we think that cost is a good one. So, or is a feasible one. The other thing I want to just say briefly is just because I'm older than Representative Babbage, and I was 21 when this thing passed, but I was not yet in Maine. I moved there the next year. So, but I was 21 when this bill passed, and I had absolutely no cognizant recognition of it at all. And it's taken me a long time to figure out really what is the role of probate courts? What do they do? My only interaction with a probate court, I've had several, but they've been on guardian sorts of issues and in Maine and those kinds of pieces. And I've had some good experiences and some not so terrific. And then I had probate experience in Massachusetts when I was dealing with wills. So I have some understanding of it. But my point is, I think my critical point is, I think that a well-run, well-supervised probate court system can help us with the current and any future slip into a backlog in the district court. And also that we just can't make a final decision, each of us individually, whether we think the cost of this is worth it until we tell OPEGA what it is we want to do, and they tell us what the accurate cost is. Thank you very much.
Thank you, Representative. And it's OFPR that's the alphabet soup you were looking for. Representative Thorne, go ahead.
Thank you, Madam Chair. And I would just say at this point that I would ascertain that most of us know which way we're going to vote on this, and to use a phrase that you've used in the past on other work session bills, I request respectfully that we move to the motion on the floor and vote.
Is that a motion to call the question, Representative, which I believe we would have to vote on? Is that what you're, or is it a suggestion?
It was just respectfully requesting that we save the committee's time, as I assume that everybody knows how they're going to vote on this today, that we move to the motion on the floor.
Okay, thank you for that suggestion. And it looks like we just have one other person who wishes to speak. And so I would like to give Representative Moriarty the courtesy of speaking, and then we can move on to the vote. Thanks again for the suggestion. Representative Moriarty, go ahead. We're not able to hear you.
Thanks, Madam Chair. I think Representative Thorne makes a good point. I don't need to tell everybody how old I was or where I was in school, though I was here in Maine, and a high school student in Auburn, and I have no memory of this vote whatsoever. No idea what the issues were at the time. And I don't know why that legislature in the second session, beginning in January of '68, coming fresh off that November vote, didn't pick up the ball and run. But that is what it is, and we can't do too much about it. If there's no one else lined up to speak, Madam Chair, and apparently there are no hand is raised, I will move to call the question.
It looks like committee members are all ready to vote. And so
maybe it's not necessary.
Yeah, I don't think it's necessary. So
that's good.
Okay, no other hands are up, and it looks like we're ready to vote. And our committee clerk, Susan Panett, has joined us. You may proceed with the roll call.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I will recall the absentees. Senator Sanborn. Senator Sanborn is absent. Madam Chair, I have 8 members voting in the affirmative, 5 members voting in the negative, and 1 member is absent. That is the call. That is the vote of the committee.
Thank you. For those who voted against the pending motion, could you please let our clerk and analyst know what your report will be?
Ought not to pass.
Ought not to pass.
Ought not to pass.
Same.
And Representative Libby, is that where you are as well? Okay, great. Thank you, everyone. And with that, Janet has a question for us.
Sorry, there were a few minor technical things that I had questions on, and I didn't know if the majority ought to pass as amended wanted to allow me to speak with. I mean, it'd be hard to talk to everybody if you wanted to delegate Representative Harnett because you made the motion, or Senator Carney was because she was on the commission, for those tiny little tweak things that I need to just make sure are right. They're all highlighted in the chart that I gave you.
Okay, and then would you bring would we then do a language review with those?
Absolutely. And I would mark up that this was a change made and for whatever reason.
The technical changes. Okay, is that acceptable to those who are on the majority report?
Yes,
it is.
Nodding heads. Thank you for that suggestion, Janet.
Thank you.
And I'm happy to do that, Senator Carney, if you want to have one less thing to on your list.
Okay, thank you. All right, everybody, that concludes our work session on LD 1950. Thank you all for your hard work and thoughtfulness this morning. We'll reconvene at, I believe it's 1 o'clock. Let me just double check here. It will reconvene at 1 o'clock for our afternoon work. Representative Thorne, your hand is up. Did you wish to speak?
Yes, Madam Chair, thank you. I just wanted to remind the committee that I will not be in attendance this afternoon so that I may attend my coronation.
Thank you. And thank you for closing out our morning with a smile. Anything else, committee members? All right. See you all at 1. Thank you.
Thanks.
Hello again, Steve.
Oh, hey there, Tom. Hey. I'm just trying to figure out what's taking place the second half of this afternoon, so I think I'll wait for Peggy to tell me.
Yeah, we just had some more stuff added to our day,
Oh,
which
we
is
did?
good. We might do some language reviews, Peggy, at the end of the day.
I have a couple of amendments for you to review. Thank you for mentioning that. But that's if you have time after getting through all the Government Evaluation Act response, and then your quasi-independent agency review, which are both required by statute, and then the RLONA presentation by Secretary of State Bellows, which you can then report out legislation.
Right, and I'm prepared. I'm going to do those things at the end of the day. I'm going to need your help on what we do with the human rights stuff, if you can.
Absolutely, yes, yes. And those were in the packets I sent to people's desks yesterday.
I've got that. I'll still need help.
All right, I'm here for you.
Thank you. Not afraid to ask for help.
And I'm not afraid to say, I have no idea.
But fortunately for us, you rarely say that.
Hey, Peggy, Janet was able to send me that map of the state showing Indian properties and territory and so forth. But so far, we haven't located a map of the water district. Oh, muted.
She is working on that. She has a
Yeah.
whole series of questions she's sending out to different people to collect information. Yeah, I mean, sometimes you folks have questions and we do not have answers.
Oh, sure, sure.
But we do our best.
Well, sometimes without a geographic understanding of what you're talking about, it's more difficult than it is in its own right.
Right. And I love maps to begin with. So
Me too. Me too.
yeah. So I kind of need that kind of picture on the ground.
Absolutely.
Maybe more than other people do. But
No,
yeah, I
I'm in the
completely
same.
understand.
I'm in the same boat. I had a history professor who used to say that history without geography is like history in a vacuum.
As a former geography doctoral candidate, I endorse that message.
Yeah, it certainly captured it for me. So, Erin, you were a candidate for a program?
I was ABD in a program. I had completed all of my doctoral work except for the dissertation.
Oh,
Yeah.
I see. Yeah, interesting.
Yeah, it was, I love the discipline, but I realized at a certain point that I didn't want to be a geography professor, which was what I was qualifying myself for.
Yeah, sure.
But I still, I still have a lot of friends in the discipline and friends and former students who went on to study law and practice and become planners and architects and all kinds of adjacent stuff. So.
Oh yeah. Okay.
It looks like we have a quorum now. So I think what we'll do is we, first of all, welcome back everyone. And we can continue with our afternoon work sessions. Let's see, the first matter that we have before us is the work session on LD 1934. And I'm just going to see if the bill sponsor is available to join us. I do not see her. But I think that we are probably ready to begin our work on this. And so I'll open the work session on LD 1934. And as always, we'll start with the bill analysis from our OPLA analyst, Peggy.
Great.
Thanks,
Thank
Peggy.
you very much. This is LD 1934. It's a resolve changing the identifying and reporting responsibilities and extending the reporting deadline for the identification of places in the state with offensive names. This is based on a resolve that was passed last year that directed the Department of Agriculture, Conservation and Forestry, where the kind of the naming entity is within that department, to work with the Permanent Commission on the Status of Racial, Indigenous, and Tribal Populations to identify places in the state that had offensive names and to do some more work on that and identify how to change them, establish a uniform process for renaming them, continue to look at, this was a difficult chore, duty, explore the most effective methods of identifying the individuals, entities, and institutions in the state that profited or benefited from in any manner from the global economy of enslavement, and to submit a report about all of that to the Judiciary Committee by December 1st of 2022. It was not an emergency, so they didn't get started until October. And once they got going, they realized that they weren't going to be able to take care of everything, and that they were going to recommend, they did submit a report, which you should have, and we've posted it. But they also recognized that it should probably be the permanent commission to kind of take the helm of this. And then not only that, the permanent commission would create an advisory committee on reconciliation and place names within the commission that would allow more public participation and input about which places, which sites, which things identified on maps have names that are offensive. And so what this resolve does is kind of shift the responsibility more to the permanent commission. It directs the permanent commission to create that advisory committee on reconciliation. It pushes the reporting date to December of 2022. And I think that's the extent of what it does. The resolve, the original resolve, and it's not amended in this, says that it needs to complete all these responsibilities within its existing resources. So my understanding is no one is asking for any kind of appropriation for this resolve. I hope that gives you the information you need, but let me know if you have questions.
Committee members, are there questions for Peggy?
Yeah.
Go ahead, Representative Moriarty.
Thank you, Madam Chair. Peggy, we may have covered this the first time, but what in fact is the process for replacement of place names?
Right. I think the report identifies that there are a couple of ways to do things, and none of them are necessarily sticking. I mean, there's a process to file a complaint with the Maine Human Rights Commission. Maine Human Rights Commission, I don't believe, has authority to change a place name. There is, let's see, it's called to the BGN, which is the U.S. Board of Geographic Names, which is part of the U.S. Geological Survey. So that's kind of a federal entity that takes care of those things. And so there's a process to move those suggestions to the federal level. And it looks like approval by a municipality needs to happen for that federal process to happen. I know in the past, because I helped the committee on a bill that identified additional names that were offensive, and that we worked with the Department of Agriculture, Conservation and Forestry, the Geological Survey folks, to deal with it at the state level. So part of what this resolve is doing is going to help people figure out the process to change names. So not only they're going to be kind of a place where people can bring the advisory committee, people can bring their concerns about place names to them. They will help go through the process to have them officially changed.
Okay, thanks.
Representative Harnett?
Not a question. I am ready to make a motion if it's appropriate to do so.
Go ahead.
I would make a motion ought to pass, and we'll wait for a second and speak briefly to the motion.
All right, is there a second? Lots of seconds. Representative Newell seconds. And now you may speak to your motion.
Thank you very much, Madam Chair, and my comments will be very short and very simple. I voted for this last year. This committee voted for it because they thought it was an important project to undertake. It was unable to be completed within the time frame that we established. If it was important last year, I think it's still important this year, and all we're doing is giving more time for this work to be done. So I would ask my colleagues to please vote in support of the motion.
Thank you, Representative. Representative Hagan, I know that your hand was up right after Representative Harnett's. Did you wish to speak?
Yeah, thank you very much, Madam Chair. Actually, Representative Harnett answered my question. I was just curious as to why they would need an extension. Pretty where I know that it was due, but there wouldn't be any penalty for a late report or anything, would there?
Is that a question for?
Well, I think Representative Harnett, you answered my question for me. Am I correct?
We're just giving them more time to complete the task.
Yeah, okay. Thank you.
And if I could just clarify one more piece, is that the resolve gives the Judiciary Committee of the 131st Legislature the authority to report out a bill based on any recommendations. If there are some statutory recommendations that need to happen, then that Judiciary Committee would have authority to report out a bill. Without this resolve, that wouldn't be an automatic authority.
Thank you, Peggy.
Yeah, thanks for that additional clarification. Committee members, is there any other discussion on the pending motion? Any other questions for Peggy? Representative Hagan, go ahead.
Yeah, I just would like maybe a 3-minute corner caucus just to discuss with my folks. I haven't yet met with them today. Would that be okay?
That is totally fine. It's 1:13. Let's say 1:20. That gives you more than 3 minutes. But
yeah, I'm not going to need much, but thank you.
Okay,
appreciate
great.
it.
We'll be back before 1:20, shortly before. Thanks, everyone.
Thanks.
Well, I give you credit. This is the first time people are back early from our corner caucus. Well done. Just wait for Senator Carney if people can activate their video.
All right. Thank you, everybody, for such an efficient corner caucus. And any further discussion before we move on to the vote? Not seeing any. So the motion is ought to pass. And our committee clerk, Susan Panett, is here, and you may call the vote. Thank you.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
No.
Thank you. Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Representative Babbage. Representative Babbage is absent. Representative Thorne. Representative Thorne is absent. Madam Chair, I have 7 members voting in the affirmative, 4 members voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. And for those who voted against the motion, could you let us know what your report is, please?
Just ought not to pass.
Okay, thank you.
Yep.
All right, and with that, we'll close the work session on LD 1934. And we will open the work session on LD 1905. And Peggy, if you're ready with your analysis, we are ready as well. Thank you.
Great. Thank you. So LD 1905 is actually a bill submitted by the Criminal Law Advisory Commission to try to make what you passed last year work a little better. So last year you passed a bill to basically prohibit communication between a prosecutor and a defendant until before a defendant who's not represented by counsel has been able to knowingly, voluntarily, and intelligently waive that defendant's right to counsel, and that information has to be provided by a court. And the exception was for a prosecutor could communicate with an unrepresented defendant without going through this waiver process, a written waiver, an opportunity to participate in a pre-charge diversion program. So what the bill does is it tries to identify issues that it's just in criminal prosecutions, and what the prosecutor cannot communicate is anything about the facts, circumstances, merits, or disposition of a pending criminal charge against the defendant unless these requirements are met. And one is the bill is drafted says the defendant has been informed by a judicial officer of the defendant's right to counsel, including court-appointed counsel if the defendant is indigent. And current law says that the defendant has to have executed a written waiver of the right to counsel. And instead of specifically saying that in the statute, the bill would say X has waived the right to counsel pursuant to rules adopted by the Supreme Judicial Court. So we're assuming that those rules would say that it would have to be a written waiver. And then it adds, if you're looking at the bill, so the exception, right now the exception shows up in paragraph A of the bill. It's a pre-charge diversion program. And then it would also add an exception of notifying the defendant that a pending criminal matter is being dismissed. So there's no criminal case going forward, which means the defendant, I guess, isn't a defendant anymore. And then there's a new subsection 3 that says this whole section doesn't even apply to when the state has to provide discovery or other information, or notice by the prosecutor to a person that no charge is being filed. So the difference between the two paragraph Bs is, one, there is a defendant, there were charges filed, but now they're going to be dismissed. And under 3, it doesn't apply to notice by the prosecutor that a person is not even going to be charged. So if they've been arrested or they've been summoned, this allows a prosecutor to let them know that they're not going to file any charges. It's not clear that the current law would apply in that situation anyway, because they're not actually a defendant, but that's being extra clear. You had some testimony in favor that the main prosecutors were looking for more clarification. They wanted to see kind of in black and white some of these clarifications. You had nobody testified against. You had people testifying neither for nor against that basically asked whether this was necessary to make these changes, and also some questioning about a judicial officer, which I believe Laura Eustack is here from CLAC, and she will tell you that she does recommend that it go back to the court, provides that information in subsection 1, paragraph A. The defendant's been informed should be by the court of the defendant's rights. What I've included in the bill analysis, and Kathy Slattery is here for the main prosecutors if you have questions for prosecutors. Laura Eustack is here if you have questions for CLAC. What I've included in the bill analysis is kind of the genesis of this for the Judiciary Committee, which was the Sixth Amendment Center's report, and it was recommendation number 2 about prohibiting this communication, which is actually consistent with ABA model rules on criminal prosecution, I believe. And let's see. And I know that Julie Finn had testified neither for nor against, but the judicial branch thought this was a clarification. I mean, would be helpful. And I'm not sure if you have questions about rulemaking that the judicial branch would go through in order to kind of fill in the details if you make that change. Okay, I think I covered everything. Do you have any questions?
Can I ask a quick clarifying question, Peggy? So the term in paragraph 1A of section 1 of the bill, the defendant has been informed by a judicial officer. I was not paying good enough attention. Are you suggesting that that should be changed to read the court? Is that what Laura Eustack had recommended?
I think so. That's what the current law really says, is that the court has provided to the defendant a statement of all this. And I think there was some belief that judicial officer really meant somebody who was, part of the court itself, when in fact, we don't have that defined in this title. And when there are a couple of definitions in Title 15, and they're a little bit different and they're kind of wide ranging. And I don't think anybody intended a bail commissioner to be providing that information to a defendant, but in some cases, a bail commissioner is considered a judicial officer. So I think it just makes sense. Laura and I have talked about it, and it makes sense to just say that the court is required to do that.
Okay. So just a substitute of that language in an amendment.
I believe so. And I'm sure that if Ms. Ustak has a differing opinion than what I'm expressing, that she will raise her hand, or you can call on her. But I think that's where we are on that discussion.
Okay. Committee members, do we feel that it would be helpful to hear from Laura Ustak? I personally do, so I'm just going to bring her over quickly. Laura Ustak, welcome to the Judiciary Committee. I'm guessing you've been listening to the discussion from the attendee space, but we're wondering if your suggestion is that we strike from the bill the words on line 9 of page 1, by a judicial officer, and replace it with by the court. Is that your recommendation?
Yes. Good afternoon, Senator Carney and members of the committee. Yes, that's definitely my recommendation. That was honestly just a drafting oversight, and I should have made it consistent in the first place.
Okay, and so if we change the wording, it would be more consistent with the wording in other parts of Title 15, is that?
Yes, that would make, well, it would be consistent within this, within section 815.
Okay.
And 1A is really, it's a little bit repetitive with 1B anyway, because 1A is really spelled out in more detail in 1B. And I think anybody reading the statute at a whole would look at 1B and say, oh yeah, of course they mean the court in 1A, but it's definitely much cleaner and more elegant to use the same words in both places.
Thank you. That's very helpful. Committee members, are there any questions for Laura Ustak? I think you've answered our questions really efficiently and well. Oh, we have one more question from Representative Harnett. Go ahead, Representative.
I'm sorry, it was not a question. I was going to make a motion if there were no additional questions.
Okay, let me just see if there are a couple of hands up. Okay. Representative Evangelist, did you have a question for Laura Ustak?
No, you closed that part of it, but I want to move. I'm not sure we need this bill. There's a lot of loopholes there. I'm certainly comfortable with correcting the drafting error, but I want to hear from one of the defense counsels on the call, and if they think this bill will help defendants' rights, then I'll vote for it. So could you please bring Tina Nadeau in 30 seconds and let her tell me?
Yep, I just want to clarify. So it does seem like we've asked all of the questions we had for Laura Ustak. So Laura, I wanted to thank you for being here this afternoon. We appreciate your help with this.
You're welcome, and I'll stick around just in case anything else comes up.
We appreciate that. Thank you. And then Representative Evangelos. Well, first of all, let me just take people in the order in which they raised hands, and I'll go with Representative Harnett, and then Representative Evangelos, and I will bring Tina Nadeau over, and then Representative Hagan.
My hand is down. It was for the purpose of making a motion. Thank you.
All right, let me bring Tina Nadeau over. And then Representative Evangelos, I think it'd be helpful if you could restate your question to her.
Okay, once I see her on the screen here.
Yep.
There she is. Good afternoon, Tina.
Good afternoon. How are you today?
I'm fine. Thank you. Thanks for asking. So it sounded like a lot of loopholes to me. I felt we were trying to get away from this kind of a contact. And certainly, in my opinion, I don't think we need to codify into law the obligation of a prosecutor to tell somebody that there's not going to be any charges brought. Best practices should call for that anyways. I'm shocked if it's not happening. So tell me why I should vote for this bill if the defense counsels are behind it.
Well, Thank you. So I think loopholes is accurate. I think this bill makes things squishier than they need to be. The current law is pretty black and white, and the confusion has been created by the prosecutors for really, and I'm being 100% honest here, not wanting to implement this fully. It's inconvenient for them. To go back to a point I believe that Ms. Reinsch made earlier, these people, for the most part, the exceptions that are carved out are not even criminal defendants in the first place. So prosecutors are already not prohibited from having contact with them to determine or to communicate that there's no charge pending, that a charge has been dismissed, or to provide discovery. That's not prohibited under the current law. I think the real issue I'm seeing here that I'm concerned with, I'm glad that CLAC is agreeing that judicial officer was way too broad. So thank you. That was something I brought up in my testimony as well, to bring it back to the court. But why would this committee, now that the law says it must be a written waiver done in court, now defer to the judicial branch to adopt rules that are not currently in place to develop a procedure around that? It seems strange to me that this law would give that authority back to the judicial branch, where again, it's super crystal clear right now. It must be a written waiver before the judge. I would be hesitant to endorse a bill that refers to rules that are not already drafted and not are already up to constitutional muster per the Sixth Amendment Center. So those are kind of my big concerns here.
Thanks.
Yeah, thank you.
Committee members, are there other questions for Tina Nato? Representative Moriarty, is your hand up with a question for her?
It is actually, yes.
Go
Thank you,
ahead.
Madam Chair. Ms. Neto, I just need to understand, because it's been some time since I was in the milieu of criminal actions in district court. Is there a waiver form that is generally used around the state right now?
I can't speak to the state. I know in Cumberland County, a form was developed specifically for that, yes. And I would imagine that it is being shared because it's important and it should be standardized.
And is the form working in your experience?
In Cumberland County, yes.
Yes. Yeah.
Yes. Yeah.
And it was not the result of a rule by court. It was just simply written and published and distributed.
It was from the statute itself. You know, it said a written waiver executed by the court or in front of the court after a full recitation of the person's rights. So that's already in the law, and they responded with a waiver form. And I think it's working well, and we should give it more time to continue to work well.
I see. Okay. So your point is this is this reference to the court adopting rules is redundant and unnecessary?
Well, it leaves it up to the question, whereas right now it says written waiver in court. If you're deferring to the judicial branch, they can create a separate process and it wouldn't be in violation of the new statute. I think the way it's working is fine. There's no need to kick it over to the judicial branch to figure it out because the statute is crystal clear as it is.
Okay. Okay. That's good. Thanks.
Yeah.
Representative Harnett?
Thank you, Madam Chair. Nice to see you again, Tina. Thank you for being here.
Yes, sir.
And I may need to ask Laura Ustak to be brought back in as well. But my question is, given your concern regarding paragraph C, if we left paragraph C as it was, in the language, the defendant has executed a written waiver of the right to counsel in each prosecution period, does that alleviate your concern? And I assume your concern is what if rules are developed that does not require a written waiver? Is that?
Yeah, thank you. That's definitely one of my concerns, and that would help address that particular concern. I think the clearer we can make that and put it into statute, the less ambiguity there is down the line.
Okay. And thank you for that. And could you bring Laura Ustak back?
Absolutely, but let's finish with questions for Tina Nato first, just because I don't want to be moving people back and forth. We can kind of maintain the same pattern we do when we're in person. Representative Hagan, did you have a question for Tina?
My question was answered a couple of times, but Representative Harnett piqued my further interest. So Ms. Neto, if C were taken out, what other problems could you specifically say hinder the process that works?
So I submitted pretty lengthy testimony last time, written testimony, and I highlight some of the issues. Again, I think the current statute is very clear. And anytime we start to expand it or carve out things, I think Attorney Ruffner last time mentioned some unintended consequences of that, because right now it prohibits communication. I think it's clear for people who are actually thinking seriously through these issues that providing discovery is not a communication. Providing an offer, a plea offer, for example, that would be a communication, right? Like an offer to plead guilty, what the fine would be, what the sentence would be, et cetera. So that's already prohibited, and allowing someone to provide discovery is already allowed under the Constitution. So I think it's just, we're getting a little too, it comes back to whether it's necessary. And I think we all agree that we have enough laws to go around. We have enough complicated laws to go around. So if something is already clear and working right, we don't need to be adding to it.
All right, you confirmed my thoughts as I went through this before and yesterday and today. It seemed redundant and unnecessary, and you have confirmed that. Thank you.
Thank you.
Any other questions, committee members, for Tina Nadeau? I am not seeing any. Representative Harnett, your hand is still up. Is that with another? No, okay. All right, thank you so much for providing your previous written testimony and answering the questions today.
Of course, thank you all.
And so we've had a request. Representative Harnett, can you remind me who you wished to ask the question of? Was it Laura Ustak? No, okay. All right, we'll hear from Laura Ustak next, and I'd encourage committee members to ask her your questions, and then we've got a couple of other folks who we may want to hear from.
Hello, Ann.
Welcome back. Representative Harnett has a question for you. Go ahead, Representative.
Thank you. Nice to see you again, Laura. Thank you for being here. I am sensitive to Tina Neto's concern regarding paragraph C, because it refers to a rule not having been enacted that has not yet been adopted, so we don't even know what it will say. Is there a problem with keeping, in your mind, paragraph 1C as is and striking those amendments and making it simply the defendant has waived the right to counsel in each prosecution? I'm sorry, has executed a written waiver of the right to counsel in each prosecution, period.
No, I think that would be fine. And as a practical matter, it doesn't strip the Supreme Judicial Court of its rulemaking authority in any event. All it means that if the court were to adopt rules pertaining to waiver, it would include in those rules the fact, or it would include or definitely not contradict the statute with respect to whether or not it's in writing. That's all.
Thank you.
Committee members, additional questions for Laura Ustak? Okay, I'm not seeing any. So once again, we'll turn you to the attendee part of the meeting. Oh, just a moment. Representative Hagan, did you have a question for Laura Ustak?
No, nope. I had a different one.
Okay. We have some prosecutors here as well in the attendee space with Andrew Robinson has his hand up. I think that he would like to weigh in on this matter. Representative Hagan, did you want to ask your question before we bring him over?
Actually, I just wanted to hear from more people, and you're bringing some prosecutors in. I was also interested in Mr. Andrews, bringing him in just to hear what he had to say about everything as it finalizes here. So great. Keep it going.
Okay, so we'll hear from Andrew Robinson and Marianne Lynch, both of whom are prosecutors, and also from Justin Andrus. And we'll start with Andrew Robinson. He may not be available. Okay, he is joining us. And Andrew Robinson, if you could please activate your video so that we're able to see you, we'd appreciate that.
Actually, this is Kathy Slattery. I would use the same link that he used.
Okay.
So there might be, I can sign out and sign back in if that would help.
Let's see. I think that Andrew Robinson is also here, so let's see if we can bring him on instead. I originally got a message that he was declining to join us, but I think this effort will be successful. Hang on. Okay, and Catherine, I'm going to send you back to the.
I'll go. Thank you.
Did everybody see Kathy Slattery trying to steal my video time? That happens at every meeting, and I thank you for allowing me to address the committee, and especially thanks to Representative Harnett for taking the time and going through this proposed amendment with us. I want to start by saying we do not wish to go backwards, and we are not trying to reverse course on protecting the rights of an individual, especially with regard to their rights to counsel. We are bumping into some practical components, and although I hear Attorney Nato saying this is a non-issue, for prosecutors, we are constantly feeling challenged and concerned that we are bumping up against this law, and that we're in order to ensure that we're complying with the law, we're having to make some decisions. By way of example, the discovery is absolutely, I think, something we have to provide. If you got to choose, whether I don't think it's a communication, I think it can be provided. But in my district, you get a cover letter that explains that your discovery, the videos are available through a cloud drive service, that there's a mechanism or a method by which you would get access to it. And that is a communication. It's not an offer. It doesn't get into the substance of the case. I'm not interested in doing that with a person who hasn't been informed of their right to counsel, but I do want them to know how to make sure they have complete discovery. So it's a very generic, this is your discovery package, this is what it contains, here's what else is available for you, and here's how you go about getting access to it. That would be a communication, and I think a strict reading of this statute, that's a violation of the law. What also is happening, minor things that will neither make or break the system, but a person standing in the corridor asking for information, where's the restroom? Where is the courtroom that I need to be? Are you the district attorney, or do you work for the DA's office? All of which there's no exception for. There's to be no communication. So it leaves us in this arena where civility or common sense responses aren't available to us without violating the statute. Putting in the language that says, concerning the facts, circumstances, merits, or disposition of a pending criminal charge against the defendant limits the scope of this protection to the case that's actually before the court. And I'm telling you now, it's not an attempt to do an end run. It's not a goal of weakening or watering down. We want to honor the person's right to counsel and to ensure they're making that decision only after having been informed of their rights. But there are these other sort of circumstantial communications that should occur. That discovery letter is significant. And frankly, I continue to give it to folks because it gives them instructions. But I'm constantly in the back of my mind thinking, well, we're in violation of the statute while we're doing it. So we're asking for an amendment that allows us to have that communication that is not substantive, but procedural, or at a minimum, giving them full access to their discovery without violating the statute. I would indicate, I know there was some thought of, hey, if you're dismissing the charge, they're not a defendant. There are times where we dismiss a charge, but it may be because there's more investigation that needs to occur. And so we don't want to communicate with somebody if we know that the charge may resurface. Having something that allows us to just say that no charge is being filed gives them notice they don't need to be in court for the day they were summoned for, but we don't want it to be a blanket, hey, it doesn't mean you're never going to be charged again. I think a strict reading of the statute as it is today, in our minds, if we think there is a chance they'll be resummons, then we shouldn't be communicating with them. Giving us that exception at the bottom allows us to say that charge isn't being brought, you don't need to be at court, end of sentence. But it may be there will be a charge coming later on as we get more information. And so we don't want to cross that line. Finally, somebody mentioned in passing, and I think a lot of my colleagues are actually mentioning this sometimes, but when you look at Section C, a lot of people say that the waiver has to be executed in court. But when I read Section C as it currently is, I don't think it requires that. It simply says the defendant executed a written waiver of the right to counsel in each prosecution. It doesn't say in court. I only mention that because if that was the goal, you probably ought to add that in there. But as it stands, I think an individual can execute it wherever they are standing when they receive the document. So if you ask me, are there other examples where things are getting a little quirky because of the statute? There are cases. The ones that come to mind immediately are animal cases. When a possession of animals motion is filed, so for the forfeiture of animals in a cruelty to animals case, the person may be charged with a cruelty to animals, but the possession of animals hearing is going to take place first. If that person is unrepresented by counsel, we cannot communicate with that person. So we can't talk to them about surrendering the animals or what the state's trying to accomplish. All of that communication can't take place unless they have an attorney, because even though we're not dealing with the criminal charge, they are charged with a crime. So we are finding occasions where we can't communicate with an individual over a matter that isn't the criminal charge, but is substantively related and is civil in nature. And the criminal charge's existence, this statute prohibits any communication. So having it tailored specific to the criminal charge would allow for communication to occur under those circumstances. I may not have explained that very well. But.
Thank you, Andrew Robinson. Let's see if, because committee members may have specific questions for you.
Oh, you don't want me to just extemporarily speak for hours on end?
You've given us a good explanation, but I think that honing in on specific questions is probably appropriate at this time. Representative Evangelos, go ahead with your question.
Thank you, Madam Chair. And hi, Mr. Robinson.
Hi.
Mr. Robinson, I'm pretty sure I've checked the record. I can't find it. The main prosecutors, it doesn't look like they testified on this bill. Can anyone verify that, Peggy?
I believe Natasha Irving submitted written testimony saying they were in favor, but she wasn't able to attend the hearing.
Okay. And Madam Chair, we held the public hearing. Clack has weighed in, Mr. Robinson's weighed in, other people are going to want to weigh in. We're getting to the point where we're holding another public hearing. Representative Harnett attempted to make a motion, but I don't want to keep going around and around on this. I think we've heard from both sides, just my opinion.
Okay, thank you. Appreciate that comment. Committee members, are there other questions for Andrew Robinson? I'm not seeing any, so we will send you back to the attendee portion of the meeting. Thank you so much for joining us.
Thank you for having me. I appreciate your time.
Okay, and committee members, is there any other information that committee members feel they need at this point? Senator Keim, go ahead.
Thank you. Before we vote, I would like to have a corner caucus, and then I might like to second Representative Harnett's motion if he would want to restate it before we did that. But I just did want clarification on his motion if he still has that out.
Okay, let's start there. Thank you. Representative Harnett, do you want to state your motion?
Gladly. Thank you, Madam Chair. And let me walk through this slowly so I get it as close to right as possible for Peggy. I will make a motion ought to pass as amended with the following amendments. In paragraph 1A, it will now read, the defendant has been informed by the court, and then striking out the words by a judicial officer. Paragraph 1C, I would amend to read, the defendant has executed a written waiver of the right to counsel in each prosecution, comma, in court, period. Striking all of the new language that was originally proposed.
Thank you, Representative Harnett. Senator Keim, did you want to second the motion?
I think that I need to walk through that a little more closely before I do, because that seemed a little different. I thought that his motion before was that he was changing the language that Laura Ustak recommended. And so I'm going to need to make sure that I read that a little more carefully before I second his motion. Thank you.
If I was unclear, I was accepting the language that Laura Ustak recommended for paragraph 1A. And then with paragraph 1C, I am going back to the statute that was as it was originally enacted, and simply adding the word in court at the end of that sentence to address the concern raised by Andrew Robinson. And it strikes the reference to the rules which have not yet been adopted to address the concern raised by Ms. Neto.
Did you want a few minutes to think, Senator Keim, or how?
Yeah, I'm just reading through that right now. Thank you.
All right, we'll just take a moment. Senator Keim, go ahead.
So can I just clarify with you, Representative Harnett, can you repeat the 1C part again? So you're saying that in 1C, you're leaving it as it was originally written, but adding in the word at the end, in court? Is that what you said?
Maybe I didn't say it artfully enough. I meant that I was leaving it as it was enacted by us last year, so that all of the amended language that you see is removed. Everything that was stricken out is back in.
Right.
And added the two words in court at the end to address the concern raised by District Attorney Robinson.
And then section 2 of the bill stays in.
Correct.
Okay, so there's a change in 1A and there's a change in 1C, and other than that, it's the bill as written.
As you see before you as printed.
Yes. I and after that very lengthy time, I will second his motion.
Thank you for being so thoughtful. Okay, so we have a motion ought to pass as amended by Representative Harnett, seconded by Senator Keim. And now we can have discussion on the motion. And I see that Representative Hagan has either a question or would like to contribute to the discussion. Go ahead.
I would be very interested in hearing Mr. Andrews and I don't want to say her name improperly. Let me cheat and look at the attendee.
Yeah, thanks.
Ms. Ustak. I'd like to hear their thoughts on Representative Harnet's changes.
Okay, let's start with Justin Andrus. And thank you for the question. And I will also bring Laura Ustak over. Justin Andrus, thank you very much for being here today, both in the attendee space and for joining the panel. Let us know if you would like Representative Hagan to restate his question, and if not, you can go ahead and answer it.
Yeah, yes, please. I just want to make sure I answer the right question.
Well, I had a question earlier, and then the motion gave me another question. I was interested in hearing just how you felt about the bill as it sat before a few minutes ago, and then I would be interested in hearing how you feel about the amended version as presented by Representative Harnett.
Thank you. So, in my view, I like the amended version. I find it better than the previous proposal. I think the changes are functionally necessary. I agree with the proposition that none of this really should have been confusing or needing amendment under the statute as it passed last year. But from my perspective, in the years since I've met you all, I've tried to learn not to let the perfect be the enemy of the good. And if that means in this instance clarifying that these things are okay, then I see clarifying them as functionally appropriate. Just by way of example, the state in many instances, not all instances, not all prosecutors, is not providing discovery to unrepresented defendants. They need to do that. There are a couple of ways to go about that, including litigation, but the easiest way at this point is the proposed amendment to make it clear that they can do that. So I think the changes largely accomplish that. I do like the tighter waiver language, the reversion to the tighter control over how the waiver is implemented as a way of safeguarding the defendant's rights.
Thank you very much. And then Representative Hagan, did you wish to ask a question of Laura Ustak as well?
It would be the same thing. I being not a non-legal mind, it's funny. I'm in the classroom as a history teacher, and then I'm in our committee, and much more intellectually challenging, I'll tell you that. So it's fun for me to just be able to hear other professionals in this world comment on these things that sound really good to me.
Well, in some ways I envy you, Representative Hagan, because my other option when I graduated from college was a history professor. So
there you go.
So I think the amendments to the bill are fine. Again, as I indicated initially, the original intent behind the bill was just to make things, as Mr. Andrews indicated, functionally easier for everyone, and to eliminate questions with respect to how it should be applied or interpreted.
Thank you very much. You all set, Representative Hagan?
Yes, thank you very much. Appreciate it.
Thank you. Those were really helpful questions and answers as well. Committee members, I'll take them one at a time. Does anybody have any additional questions for Justin Andrus? Not seeing any, and any additional questions for Laura Ustak? I am not seeing any. Committee members, is there any additional discussion of this, the pending motion? Is the committee ready for a vote? Representative Hagan?
Yeah, I would like to speak with my folks just for a few minutes, another short one if I can.
Okay, let's have a corner caucus, and we'll try to return around 2:05 or so. And if you need additional time, just let us know. Thank you, everyone. Committee members, if you are able to activate your video, I think we're ready to resume. Okay, it looks like most of us are back. Committee members, are we ready to move on to a vote on the pending motion? Okay. And Ms. Panett, if you were able to join us.
Madam Chair, I am able to join you. You do have a person, you have two people on the screen that are not committee members. Do you want to move them first or have me call the roll?
Yeah, I will. Thank you for that reminder. I will move them over. Their cameras are not activated, so I can't see them, but I will move them over and give me a chance to do that before you call the roll, because I think that's a good practice. Thank you. Representative Evangelos, did you wish to be recognized?
Yes, Madam Chair. I've read the testimony from the main prosecutors from Ms. Irving. It's 2 sentences long. There's no substance to it at all. Just that, you know, folks, Sixth Amendment Center, the prosecutors in certain locations were violating the constitutional rights of our defendants. We try to tighten up the regulations and they come forward with a bunch of loopholes. I'm not voting for this. And I just not satisfied that they've made enough of an effort to change their practices to ensure the constitutional rights of our defendants. Seems like pretty low bar stuff they have to do. And the testimony from the Prosecutors Association makes no case at all as to why it should be changed. I'll read it to you. On behalf of the Maine Prosecutors Association, I would like to testify in support of this bill. Necessary changes were crafted by multiple stakeholders, i.e. prosecutors, to address significant logistical problems with the law change. That's the extent of the case they made, which is no case at all. So I just wanted to let you know why I wasn't voting for it. Thanks.
Thank you, Representative. Is the committee ready for the vote? Appears that we are.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Sorry, yes.
Representative Hagan votes yes. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne. Representative Evangelos.
No.
Representative Evangelos votes no. Representative Newell. I'll recall the absentees. Representative Babbage. Representative Babbage is absent. Representative Thorne. Representative Thorne is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 9 members voting in the affirmative, 2 members voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you. And Representatives Evangelos and Poirier, could you let us know what your report is, please?
I'm going straight ought not to pass.
Thank you.
Same.
Same. Okay. Thank you both. The motion carries 9-2 with 3 absences. And with that, we will close the work session on LD 1905. And we are going to open the work session on LD 1926 next. And I did want to note to those who may be listening or watching on YouTube that committee members are being pulled in a lot of directions these days as we get close to the end of committee work. And so you'll notice that some of us are occasionally absent, and just know that we are being pulled in a lot of directions. Thank you. And so we'll begin the work session on LD 1926. This is a resolve regarding the legislative review of the fee schedule pertaining to the Maine Commission on Indigent Legal Services.
Right, thank you. So this is one of the few situations that the legislature has to review rules that are adopted by agencies, and in this case, an independent agency. Once you give them the authority to go forward with those rules, the only rules that are major substantive rules which require your review that the Maine Commission on Indigent Legal Services makes are rules with regard to compensation. And so the rule that this resolve refers to raises the compensation level for attorneys that are doing work that the commission that they're appointed to from $60 per hour to $80 an hour when that work has been completed after, or when that work is done after the effective date of that funding in the budget. So I believe it's July 1 of 2021. And I know that Justin Andrus is here and he can clarify that. I apologize that I don't think I ever gave you a copy of all the rules. And we can look at those if you want, but the process of your process here is once an agency submits their major substantive rules that have been provisionally adopted, so it goes all the way through the process of, notice of rulemaking, public hearing, comments, getting signed off by the Attorney General's office. They're provisionally adopted by the agency, and then it comes to you for review. They submitted it by the deadline, which means that a resolve gets prepared. And the only way that they do not go forward with finally adopting those rules is if you amend this resolve to say, do not adopt the rule. Or you could amend the resolve to say, adopt the rule with these changes. But you can vote, if you vote ought to pass on this resolve, they can go forward and finally adopt these rules. I think I laid out that process for you, your different options in the bill analysis. The funding for this, I believe, is already included in the budget, so this shouldn't have a cost involved. Happy to answer any questions.
Committee members, are there questions for Peggy? Go ahead, Representative Harnett.
Thank you, Peggy. Am I correct that there was no testimony in opposition to this? There was testimony neither for nor against that simply wished that the hourly rate was higher?
Right, that's my understanding as well.
Thank you.
Any additional questions, committee members? Okay, I think we don't have any questions with regard to the bill analysis, Peggy, and Representative Reckitt's hand is up. Representative, go ahead.
I'd like to move on to pass.
Thank you, Representative. Is there a second? Seconded by Representative Harnett. And let's, I guess, since it doesn't seem that there are additional questions of Peggy, if we could I'll ask committee members if there are any questions of the Executive Director of the Maine Commission on Indigent Legal Services, who is in the attendee space if we had questions. I am not seeing any questions. Is there any discussion of the pending motion? Not seeing any discussion. Is the committee ready for the vote? It appears that we are. And Ms. Panett, thank you very much for appearing once again to take the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
No.
Representative Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Keim. Senator Keim is absent. Representative Babbage. Representative Babbage is absent. Representative Thorne. Representative Thorne is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 2 members voting in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much. Committee members, Representatives Hagan and Poirier, if you could please let us know what your report is.
Ought not to pass.
Thank you both.
So can I just clarify that ought not to pass does not deauthorize the commission to adopt these rules? As long as you're aware of that. If you don't want these rules to be adopted, then the actual report should be an ought to pass as amended that withdraws the authority that says, no, do not adopt these rules. And I'm not sure if that's what you're trying to say. Just saying ought not to pass shows that you're not supporting the resolve going forward, but it wouldn't, if the whole committee didn't want to adopt the rules, then an ought not to pass wouldn't have that effect. I just want to make sure you understand. I know this is a very complicated kind of counterintuitive process, and I just want to I want to make sure that what you're going to get the result that you want to get.
Can I call you later and then just amend my vote?
If you amend your vote, then you would have to reconsider it in the committee meeting to
Okay.
change it from ought not to pass to ought to pass as amended.
I think this is a great learning moment. And Peggy, can you just restate, please? How you started out with your clarification. Thank you.
Right, I will try to. So the statute that provides for the legislative review of major substantive rules says that if the agency submits its rules on time to the legislature for review, which is a date in January, about mid-January, and that happened in this case, then the only way to withdraw the authority of the agency to adopt the rules is for the legislature to take affirmative action to withdraw that authority. And the way you would do that is amend the resolve to say, no, the Maine Commission on Indigent Legal Services does not have authority, may not adopt these rules, may not finally adopt these provisionally adopted rules. So that's how you would stop them from going forward. It's a completely different story if they filed their rules late, but we're not even going to go down that road unless you now. It doesn't really matter whether it's whether you vote ought to pass or ought not to pass, or you don't even take it up. As long as they submitted their rules on time and the resolve gets prepared, they have authority to finally adopt the provisionally adopted rules unless you pass something that says do not do that. Is that any clearer?
That's
helpful. Representative Hagan, go ahead.
Thank you very much, Madam Chair. So now I'm thoroughly discombobulated. I apologize. So does that mean that our vote either way didn't matter?
I wouldn't say that. I think it does matter. Your vote matters because you have the ability to stop the process, to stop the final adoption of these rules. Whether your vote ought to pass or ought not to pass does not stop the process. The only way to stop this process is to vote ought to pass as amended, and that amendment says, no, do not adopt these rules.
Okay, thank you. Now I understand. I want to do that.
Okay, so, and I'm assuming that that's what Representative Poirier wants to do as well. Okay, so that would actually be an ought to pass as amended report.
Thank you very much. And that was a great education. I did not know.
That you will probably not use again for 10 years.
But 10 years from now, we'll all know exactly what to do. Right. All right. So with that clarification, we'll close the work session on LD 1926. And we do have some time before we resume our work this afternoon. Representative Reckitt, did you have a question?
Yes, I'm a little, now I was clear, now I'm not clear. So, is the motion then should have been, and it was me that did it, so, would have been to say, ought to pass as amended. And that amendment is, we're not going to do this rule change. And then I would make that motion and then I'd vote against it because I want the rule change to happen. No?
No, you don't need to do that.
Okay,
Voting,
good.
yeah, a motion ought to pass kind of gives your affirmative support for going forward.
Okay.
And that makes sense.
I just didn't want to get it screwed up.
Just one of the more complicated things here.
Yeah, I'll settle with my brain being screwed up, but I don't want the vote to be screwed up. All right, thank you.
I do have a couple of amendments for you to do your final check off.
Yes, thank you. I forgot. I knew that and then forgot. Thank you, Peggy.
Okay, let me, the two amendments are LD 1786 and 1918. And I will share my screen. There we go. This is LD 1786. My screen is really slow catching up. This is an act to maintain consistency in non-discrimination laws, among non-discrimination laws outside the Human Rights Act. This is a majority ought to pass as amended report. I think you've actually seen all the pieces of this. And what it does, it strikes out sections 14 and 15, and it amends. It amends the, so 14 was the Title 17 version that applied to anything that might hold, any entity that might hold a license issued by the state. And 15 was the kind of archaic language that dealt with municipal, oh no, that's later in the bill. I got to figure out what 15 is, but 17, 18, and 19 are the three dealing with insurance. And those were revised. Senator Sanborn helped do that, and those were drafted by the analysts for the Healthcare Insurance and Financial Services Committee. And those were signed off by the insurance representatives. And then section 23 of the bill is struck out, and that's the one that deals with that old language in Title 30A about municipalities and funding for schools and for public and non-public schools. We struck that out because we're not really sure what it means, so we're not going to amend it. And then the last one is about affordable housing covenants, to make it clear that the prohibition doesn't apply to, with regard to discrimination on basis of familial status, does not apply to housing for older persons as defined in the Human Rights Act. Oh, I'm sorry, section 15 that we struck out is the one about push polling. And that you decided wasn't necessary.
Right, because it was a non-exclusive list. Right. And so it didn't make sense to amend it. Yeah.
Right.
Thank you for tracking that down.
Yeah, sorry about that. I should have been more prepared. There is no fiscal impact. So the majority, if I can go forward, here's the voting sheet. The majority is ought to pass as amended. The people on the majority report are the ones who can make changes, although anybody can offer changes and do a motion to reconsider if you would like.
Thanks, Peggy. So I'll turn to those who are on the majority report. Does anybody have any concerns about the amendment? I'm getting some thumbs up, and as the bill sponsor, I felt like the amendment perfectly captures what the committee voted on.
Great.
So I think we're good with that one. Thank you.
Thank you. The next one is LD 1918. This is an act to provide for guardians ad litem. The majority is ought to pass as amended. The amendment, the bill itself is just a funding section, and it was for $400,000. And the majority report is to increase that to the estimate that the judicial branch gave you with regard to the number of family law cases, family matter cases that could benefit from a guardian ad litem where none has been appointed because the parties couldn't afford it. And so that you took their recommendation of $1,540,000. And so it's an appropriation for that. And the fiscal note basically says, here's an appropriation. And this would be a continuing appropriation going forward into the next biennium as well.
Thank you.
And sorry, here's the voting sheet. So it was 10-4.
Okay. Thank you. And committee members, any concerns?
Oh, I'm sorry. I'm not even sharing my screen. Did you need to see that?
I think why not? I think you read it to us, but the visual also helps.
Okay, so here's the voting sheet. It was 10-4, and the fiscal note is 1.54 million going forward.
Thank you. Committee members, any questions or concerns from those for whom this was your report? I am not seeing any, so I think that one also is fine, Peggy. Thanks.
Thank you.
And are there other language reviews for us, Peggy?
Don't have any more. I really apologize.
No, that's
This
okay.
means you get a break since unless you're comfortable going forward with the issues that were scheduled for 3 o'clock, which are work sessions on reviewing the Human Rights Commission's government evaluation report and talking about the quasi-independent agency policies.
I would like to make efficient use of our time, but I'm also a little concerned about deviation. Should probably wait until, I think we should wait until the appointed time that was advertised.
Okay, that makes sense.
Okay, so if we could all be back promptly at 3, we'll continue our work, and thank you, everyone. We'll be in recess until 3 o'clock.
Thank you.
Thanks, Peggy. Hi, committee members. It's 3 o'clock, and if you could activate your video so that we can continue with our work this afternoon. And Representative Harnett, can I hand you the virtual gavel?
With my pleasure. Thank you, Chair.
Thank you.
Chair Carney, and good afternoon, committee members. We have 3 more items, sort of housekeeping items, but important nonetheless, to get through this afternoon. The first 2 deal with the Maine Human Rights Commission. And you may recall that you received a while back a very large Government Evaluation Act review of the Maine Human Rights Commission, and that was presented to us publicly. I frankly can't recall the exact date, but yesterday when we were in session, we were all provided with materials related to that, and I'm going to draw your attention to the pink page, which was the Government Evaluation Act review of the Maine Human Rights Commission. And I will turn it over to our analyst to walk us through this process. And we do have Ms. Sneerson here from the Maine Human Rights Commission if there are any questions that come up that you would like to pose to her. So with that, Peggy, take it away.
Great, thank you. So as Representative Harnett mentioned, you did have the report, excuse me. So the statute provides for review of agencies over time. It's usually an 8-year cycle. Although the Maine Human Rights Commission was up for review in 2018, that was right after there had been a study about done by a group established by executive order to look at the Human Rights Commission. So the Judiciary Committee said, we're not going to go over this again, push it out to 2022. So the Human Rights Commission had to submit their report by November 1st, 2021. They did that. The Government Evaluation Act actually identifies what needs to be in that report. And the Human Rights Commission went through that and complied with all of that. And so the pink sheet you have in front of you, I think I had given you some information before about all the things that had to be in the report. Those are in the report. And this is an opportunity to look at what the Human Rights Commission is doing and determine whether or not they're operating in accordance with their statutory authority. And if you know of places where you want to change their emphasis of activity, or you want to give them more authority or less authority, this is an opportunity to do it. There used to be an audit and program review committee that would look at different agencies. This is a different process. It puts that initial step of kind of review on the agency, and they bring their results to you, and then you decide if there should be any changes. So what the statute requires you to look at, and this is the pink sheet. So they submitted their report on November 1st. They presented it in January. And what you need to look at is the extent to which the agency or independent agency operates in accordance with its statutory authority. I can share the report with you, but in the program descriptions, Ms. Nearson went through each piece of the programs that the commission carries out and identified that they were in compliance with their statutory authority. Goals and objectives, the degree of success in meeting the agencies or independent agencies' goals and objectives through each program. Again, that's in the report in the program description. Statutory and administrative mandates, the degree of success achieved by the agency in going through that. That's again in the program description. And then the last piece that the statute requires you to look at is the extent to which the agency has increased or reduced filing requirements and paperwork duplication burdens on the public. That's on page 100 of their report. And I know when Ms. Nearson presented the report, there weren't any questions. So it wasn't like she had anything to bring back to you today to respond to any of your concerns at the time. So your next step is to report to the presiding officers whether or not you think the Human Rights Commission is operating in accordance with its statutory authority. And that's the point where you would make recommendations for any changes as well.
Thank you very much, Peggy, for that analysis of why we're here today and what it is we need to do. Are there questions from committee members for Peggy about what we're doing today, or questions that have come to your mind since reviewing the report that we had presented to us in January? If there are, please raise your electronic hand. And I am not seeing any. I would also note that we have in the attendee room both Amy Sneerson and Barbara Archer Hirsch of the Maine Human Rights Commission. If committee members have any questions for them, we had the opportunity to question them about the report earlier this year. But if there's any additional questions that have come to mind, please raise your electronic hand and I will bring them over as necessary. And I see that we've already moved over Executive Director Sneerson. Welcome to the Judiciary Committee. Amy, it's good to see you again.
Good afternoon. I think it's the afternoon. Yes. Representative Harnett, Senator Carney, and members of the Joint Standing Committee on Judiciary. My name is Amy Sneerson. I'm the Executive Director of the Maine Human Rights Commission, and our Commission Counsel, Barbara Archer Hirsch, is here as well to answer any really hard questions.
Okay, so we would ask for the easy questions first for you, Amy.
Yes, please. Thank you.
Go into the category of difficult questions. Seems fair. Maybe not fair to Barbara.
Oh, it's good. She's fine. Yep.
Okay, good. Are there questions from committee members for either Amy Sneerson or Barbara Archer Hirsch? If so, please raise your electronic hand. And I am not seeing any, so I want to thank you again for the very thorough report that you presented to us earlier this year. And at this point, I would entertain a motion from a member of the committee that the Judiciary Committee, Joint Standing Committee on the Judiciary, finds that the Maine Human Rights Commission is operating in accordance with its statutory framework and authority, so that we may communicate that finding to the leadership. So I would recognize Representative Moriarty.
Thank you, Mr. Chair. I make the motion that you have just stated.
Thank you, Representative Moriarty. And Representative Evangelos, do you want to second that? Second. We have a motion by Representative Moriarty and a second by Representative Evangelos. Representative Moriarty, did you wish to speak to your motion?
A quick question, Mr. Chair. I wonder whether in the future we can do this sort of thing following the presentation. I mean, the intervention of a month or 6 weeks is a bit awkward. I don't know if there's some reason that we're required to wait or
It may have
it
been
was
one of
clearer at the time.
It may have been one of those crazy busy days that we had, but I will turn that over to our analyst who probably has a more well thought out response to that question.
I don't know if it's more well thought out, but it's kind of practical. That was a day we were having several presentations. This was the first one in the afternoon, and then you went on to, I believe it was the Maine Commission on Indigent Legal Services presenting its annual report. So we didn't pause, and we probably should have. And that's one more thing that we've learned that we can do better in the future.
Okay. All right. Good. Thanks.
Thank you. So
nothing else, Mr. Chair. Thank
you. So we do have the motion and a second that will result in a letter coming from the committee. Is there any discussion from committee members on the motion? Senator Carney.
I just wanted to echo what you said, Co-Chair Harnett, that the report we received was really detailed and extensive, and I think clearly demonstrated that the commission is operating within its authority and is doing the work that is required under the statute and doing it really well. Thank you.
Thank you very much. Is there any additional discussion? Seeing none, then I would ask Supi to please call the roll.
I would be happy to, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan.
Yes.
Representative Hagan votes yes. Representative Poirier. I didn't hear you, I'm sorry.
Yes, sorry.
Thank you. Representative Poirier votes yes. Representative Libby.
Yes.
Thank you. Representative Libby votes yes. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Keim. Senator Keim is absent. Representative Babbage. Representative Babbage is absent. Representative Thorne. Representative Thorne is absent. Representative Newell. Representative Newell is absent. Madam Chair, Mr. Chair, I have 10 members voting in the affirmative and 0 in the negative, and 4 are absent. That is the vote of the committee.
Thank you very much, Supi. We appreciate that. And with that, I will close the review of the Government Evaluation Act review of the Maine Human Rights Commission. We will now turn to a second obligation of our committee, and that is to engage in a quasi-independent state entity review checklist also regarding the Maine Human Rights Commission. This is something we are required to do in every 2 years, I believe, under Title V, Section 12,023, subsection 3. This is the yellow packet that you received on Wednesday. And again, I am going to have our analyst, Peggy, walk us through what we have in front of us. Thank you again, Peggy.
Oh, you're welcome. Thank you. So this is a process that the Government Oversight Committee recommended and the legislature enacted a few years ago that requires independent agencies to first adopt policies about selection of vendors, what they do with contributions or dues, and what they do about travel, meals, and entertainment expenditures. The statute requires certain elements be in their policies, and requires that they submit a report every 2 years, and the committees of jurisdiction review them. This is only for quasi-independent agencies, and that for any basically no bid contracts over $10,000, they explain why that happened and how those funds were used. And so what you have in this packet, the top page is a checklist of what the statute requires you to look at. And then what follows is, so every agency has to submit this information. Actually, every independent, quasi-independent agency has to submit it every year, but it only gets turned over to you on the even years, which is when you have to review it. So that the what's labeled page B is the transmittal of the report from the Human Rights Commission by the Executive Director of the Legislative Council to you. And then paragraph C is actual Maine Human Rights Commission's report on meeting all these requirements. So you will see that that paragraph, that A on page C is the actual details of their one no bid contract that was exceeded $10,000. And you can read that it was implications from COVID-19 and how they use that contract money. And they didn't have any other things that had to be reported under their contributions or anything to do with let's see, they didn't make any changes since 2018 in their policies. And if you go to page E, there's the specific policy on the selection of vendors that meets the statutory requirements. Page F is the policy on contributions that also meets the statutory requirements. And then also the policy on travel and meal expenses that meets the statutory requirements. And I'll just say that the Government Oversight Committee thought it was important for this to happen on a regular basis because there actually were some situations where a quasi-independent agency or two went outside these boundaries and wasn't spending money appropriately or at least needed to report how the money was being spent. So I don't know if you have questions about those specific policies, but I've gone through and we've identified that the policies for the selection of vendors does meet the requirements. So that's the first yes. And what you need to report back to the Government Oversight Committee are two questions, and those are the ones that are in italics. Were all waivers of competitive procurement reported in the past 2 years in compliance with the entity's policies and procedures? That was that one no bid contract with Helix. And yes, that was reported in compliance. The policies for use of the entity's resources for contributions, yes, that their policy meets the statutory requirements. Were all contributions made by the entity and reported in the past 2 years in compliance with the entity's policies and procedures? Yes, because they didn't make any over the $1,000 threshold. And then the last, so those are the two questions you have to report to the Government Oversight Committee. And then the last question is whether their travel, meals, and entertainment policies meet the statutory criteria, and they do. And you can compare this page with the actual policy if you would like. Again, Amy Sneerson and Barbara Archer Hirsch are here to answer any specific questions. I'm kind of the procedural person today.
Thank you, Peggy, for that analysis. And am I correct that most of the policies in place have been in place since 2018, have been reviewed by this committee, and have been found to be in compliance?
Yes.
Have been found to be appropriately doing what it is they're intended to do?
Yes. Yes. I think they might have had to readopt one in 2018 in order to be specifically in compliance with the law. Not that it was way out of whack, but so they were all, they've all been adopted in 2018 and they've been in compliance ever since.
Thank you very much. Are there questions for the committee analyst from committee members? I will start with Representative Evangelos.
I don't have any questions for Peggy. I was going to make a motion. I'll wait.
Okay, you can hold on because I'll probably frame the motion. Representative Moriarty, was your hand up for the same reason?
It was. I'll let you make the motion.
Thank you. I will just check if there are any questions from committee members for Peggy, and if there are any committee members who wish to hear from Amy Sneerson or Barbara Archer Hirsch. And I am not seeing any, so I would entertain a motion for the Judiciary Committee to submit this report to the Government Oversight Committee, stating that the Maine Human Rights Commission meets the requirements contained in 5 MRSA section 12023, subsection 3. And I see that Representative Evangelos, you're making that motion?
Yes, I'll make a motion as to that effect. You let Representative Moriarty get away with it. So I don't have it word for it either.
That's okay. Peggy, you have the motion. Is that correct?
Yes,
Thank
I
you.
do. Thank you.
Do I have a second? Is that Representative Moriarty?
Yes.
Did you want to repeat it to show up Representative Evangelos, or are you just good waving your hand?
I wish that the good representative would explain his motion in extensive detail.
Go ahead, Representative Moriarty, make my day.
I'll pass, actually.
Thank you both very much. Are there questions from committee members regarding the motion made by Representative Evangelos and seconded by Representative Moriarty? And I am not seeing any. So with that, I would welcome back Supi Panet to please call the roll.
Thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes, with my thanks to the Maine Human Rights Commission for the report and Peggy for her analysis, but yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Keim. Senator Keim is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Representative Thorne. Representative Thorne is absent. Representative Newell. Representative Newell is absent. Mr. Chair, I have 9 members voting in the affirmative, 9 members voting in the affirmative, 0 members in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much, Committee Clerk Panet. And with that, I will turn to Peggy. We are scheduled to hear from our Secretary of State, Shanna Bellows, regarding her report on the revised uniform law on it's a hard one, acts that notaries engage in, otherwise known as ROLONA. And I could keep saying that very slowly to get us to 3:30, or ask if it is okay for us to begin her presentation at this point. Does any committee member have a concern about beginning this at 3:23? I am not seeing any, so I am going to go out on the limb and begin this presentation 7 minutes early. I would ask, and we could do this slowly to drag it out, Supi, if you could please, if you could bring over our Secretary of State, Shanna Bellows. Secretary Bellows, welcome back to the Judiciary Committee. It's nice to see you again. Thank you for your report. And just to remind committee members, this is the green report that you received when we were in session yesterday, and it has been available electronically for some time as well. Representative Bellows, thank you for the report, and please begin your presentation as soon as you're comfortable.
Thank you, Representative Harnett, Senator Carney, distinguished members of the Judiciary Committee. I am going to share my screen. I think someone is going to make me a host or co-host because the report is somewhat brief. It's a 3-page letter with some appendices, one of those appendices being proposed legislation. I'm delighted to say that it is, let's see, it looks like I can share my screen. Okay, so I will get started. So this report was pursuant to LD 1399, which this committee passed, and then the legislature passed as an emergency. That was an act to continue temporary modification of certain in-person notarization and acknowledgement requirements and developing permanent implementation of remote and online notarization, signed into law last session. That law directed the Secretary of State to pull together a working group, and we did indeed do so. There's a complete list of the working group members in Appendix 1 of the report. It included representatives from my office, the Bureau of Corporations, Elections and Commissions, which is headed by Deputy Secretary of State Julie Flynn, and our Director of Corporations, Kathy Bodwin, representatives from banks and credit unions, advocates for seniors and people with disabilities, Leo Del Licata of Legal Services for the Elderly, and Peter Rice of Disability Rights Maine, representatives from real estate and the mortgage industries, representatives from probate and trust law practice groups, the Maine State Bar Association, Informed Notaries of Maine. We invited national experts to sit with us in this process. And then from the legislature, Senator Ben Chipman, who is a notary himself, and a representative from the Registry of Deeds. So again, that's in Appendix 1. We had 3 objectives and we held 8 meetings from August of last year through February. One was to conduct a study on remote online notarization, to then develop recommendations, and we are submitting for your consideration uniform legislation adapted with some majority recommendations for Maine. So before we get started, this is a topic I've learned a lot about, and we wanted to just introduce you to some of the terms because this is important in this topic area. So there are types of notarization. So there's traditional wet ink notarization, that is in-person notarization of paper documents. That is what we had here in Maine prior to the pandemic. There is in-person electronic notarization, which is done in person. It's notarization of electronic documents. There is remote online notarization, which is notarization done remotely of electric documents with use of multi-factor authentication. There's paper remote online notarization, or PRON, notarization done remotely of paper documents with use of multi-factor authentication. And then remote ink notarization, and that is notarization done remotely of paper documents via audio video communication, which means current temporary modification. So we sought in our recommendations to explore and address and permit all of these forms of notarization. So I want to go into the details of the recommendations, the legislation that we have attached in the appendix, but did want to draw to your attention the 18 states that have adopted what we call RMONA, or the Revised Uniform Law on Notarial Acts. This is federal legislation seeking uniformity across the country. And then there are 5 additional states in which RMONA has been introduced and still being negotiated. You can see that our neighbors in New Hampshire are on this list. So the working group recommendations, and I'm going to walk through, so the legislation, which is in Appendix 3, is many pages long, and we are available to go line by line during the work session if that is something that the committee chooses to do. But what I wanted to do was touch on the high points, the areas where there were either departures or things from existing Maine law that were important for the committee to know, areas where there might have been a disagreement in the working group and wanted you to be aware of that, and just important points. So first and foremost, the unanimous recommendation of the working group is that the Judiciary Committee adopt RLONA with modifications and pass that in this legislative session. So I just want to set that as the baseline, is we are recommending unanimously the adoption of RLONA. And that would allow Mainers to engage in remote online notarization and all forms of electronic notarization. So definitions, RLONA sets out definitions, and it is the unanimous recommendation to adhere to RLONA, but that the definition of official stamp should encompass the official notary seal. Authority to perform a notarial act. So this working group recommendation is to adhere to existing Maine law with regards to the authority to perform a notarial act. So we have imported some aspects of Maine statute into the proposed legislation here. That includes conflict of interest provisions that are existing in Maine law, limitations on who a notary public can perform notarial acts for. There was, and you'll see this in the report, there are limitations as well on notarial acts for petitions in a referendum campaign. One member of the working group disagreed with importing that piece, and we can go into more detail on that if you are interested. Requirements for certain notarial acts. So the unanimous working group recommendation, this is just an odd aspect of Maine law, was to bring in Title IV, Section 952, which is a responsibility for notaries public to perform notarial acts for protests, losses, records, and copies, which appears to be related to the shipping industry. Identification of the individual. So there was a unanimous recommendation of the working group to strike from RLONA language that a license or ID may be expired for no more than 3 years. Some notaries public require that the license or ID not be expired ever. Others, in the case, for example, with seniors or people that are known to them, might accept something that is expired for a longer term. Who may perform notarial acts? By the way, these recommendations are tracking the legislation in Appendix 3. The majority recommendation is to import language from existing Maine statute that allows attorneys at law duly admitted and eligible to practice in the courts of the state to perform notarial acts. As well, it is also a majority recommendation that uniform acknowledgement of the notarial acts of other jurisdictions be recognized, and that is fundamental to the constitutional principle of interstate commerce and should be adopted. Notarial acts performed for a remotely located individual. The majority recommendation was to permit any notarial officer, including notaries public, attorneys, judges, clerks, and deputy clerks of the courts, to perform notarial acts for a remotely located individual in accordance with the criteria established in the draft language. And this would also include security measures such as identity proofing and recording requirements. Certificate of a notarial act. So the majority recommendation is to require a certificate of the notarial act that includes the date of expiration of the notary public's commission and the official stamp. Now, this is a departure from existing requirements, and one member of the working group felt that requiring the official stamp would be a burden on notaries public and should not be included. That said, there was unanimity around the procedures for destruction of the stamp under RLONA when the commission is expired. Journal requirements. This is another departure. Maine does not currently require a journal for notaries public, but the majority recommendation was to adopt the Rolona recommendation that all notarial officers except attorneys at law be required to keep a journal of all notarial acts for record-keeping purposes. One member of the working group felt that no journal should be required. 2 other members thought that attorneys at law should be required to keep journals as well. 10 members of the working group thought attorneys at law already keep substantial records, so a journal was unnecessary for that sector, but necessary for
Secretary
yeah.
Beth, let me, do you mind if I stop for questions as you go through?
Oh, please, that sounds great. And I can stop sharing my screen if that's easier, but happy to take questions. And if I can't answer it, I know Deputy Secretary Julie Flynn is with us, and I don't know if I saw it. I know our Director of Corporations, Kathy Bodwin, is also happy to answer questions.
Senator Sanborn, did you want to ask your question now?
I would, if that's okay, just because I anticipate that I might lose it otherwise, which is that that certificate of notarial act with a seal has not typically been required of attorneys. They generally just write their bar number when they notarize something. So is that a change, and are attorneys going to have to obtain a seal in order to be able to perform notary duties going forward?
So I'm going to direct that question to
Julie is saying Kathy.
Kathy Bodwin, yes. But I also want to bring your attention. So section 15 in the legislation is very specific about the certificate of the notarial act. And I'm trying to see if the attorney bar number is sufficient. Kathy, Director Bodwin, do you know the answer to that?
I believe that we didn't address that when I don't think it was discussed. And so you are correct that I believe that the way that it's drafted right now, that you would be required to use a stamp as well. So we would have to make, consider some amendments to that. We'd have to discuss that further, because I believe the language as we have it right now would require you to use the stamp. But again, I'm not 100% certain because I'm trying to find it myself here, and we did not address that.
Okay.
So we'll bring that information back to you. One of the things, so the official stamp is only required if the act is performed by the notary. So attorneys are not being required to do the stamp. That's explicit in subsection 2. It says if a notarial act regarding a tangible record is performed by a notary public, an official stamp must be affixed to or embossed on the certificate. And that's, you can read that in subsection 2 of section 15, certificate of the notarial act.
Yep, I see it. So it is addressed in the legislation.
Yeah.
Right.
So your question was just about, were attorneys going to have to get a stamp?
That was my question. It
Yeah.
looks like it is actually addressed in the statute.
Yeah. No, that's specific to notaries public, because there was, and we did have a pretty substantive conversation about this, but it was decided that attorneys are doing extensive record keeping and that their bar number does identify them and does allow for due process and for consumer protections should that notarial act be challenged at any time.
Yep. No, that was what I wanted to see. It just, and that it doesn't change Maine's current practice with regard to how attorneys keep or sign off on it. And it just wasn't clear in your PowerPoint, and I hadn't gone to the language of the statute.
That's the danger of trying to condense a lot of information. I see 2 other hands raised, Representative Harnett. I can put it on pause too for other questions as people have.
Thank you. Before getting to that, can you point me to where you were?
Sure.
Where you are in the statute. I've got lots of.
Yes. Why don't I? So why don't if it's, I'm seeing that our pages weren't numbered. It was in the appendix 3. The sections of the legislation are numbered. And what we were just discussing is in section 15, certificate of notarial act. And there's subsections there that say certificate required, stamp required, sufficiency of certificate. And I can pull this report up as well on my screen to try to share that too.
No, that's okay. I found it.
You found it, okay.
To know where we were talking. And we do have 2 additional questions or 2 questioners. Representative Moriarty.
Thank you, Mr. Chair. This is on our agenda under the heading of presentation. And I'm wondering procedurally, is our committee going to offer legislation, submit legislation in accordance with Appendix 3?
We will entertain a motion about that at the end of the presentation. And if the second part of your question is, would we then have a public hearing?
Yes.
And a work session? I believe that I would answer that in the affirmative.
Then if I may follow up, I think if there's going to be a public hearing, we could save the secretary and ourselves an awful lot of time if we simply vote to submit the legislation and then schedule a hearing and listen to it all at one setting rather than hearing it all twice.
I understand that. I think you raise a good point, but I will, since I have let a few people ask questions, I'll get to Representative Reckett, but I would ask representatives to members of the committee to keep that in mind. But if you do have burning questions, I'm not going to stop them from being asked. Representative Reckett. You're muted, Representative.
As I think I've said before, I am a notary, so I'm particularly interested in this section. It's also ironic that I asked my next door neighbor, who's an attorney, if she would notarize something for me, because obviously I couldn't notarize anything on my own. And she said, no, she couldn't. She was just an attorney. And I'm going, wait, I'm pretty certain that attorneys in the state can do that, but never mind. That's not my question. My question is on the whole stamp required. I have most of the time, I do keep a journal. I just want you to know, I use the stamp to emboss, to crush the paper with my seal and all that stuff. But I also have a way to stamp that does ink, and then you fill in that. Is that also considered to be a stamp? It doesn't have to be.
And I see Director Bodwin nodding as well. And one of this was in the first slide. Yes, that stamp would also include the seal.
Yeah. And you don't have to have the gold thing that I have, but never have used. Right. Okay. And mostly what I do is marry people. So it's like, you have to pay attention to that. So I keep a copy of the marriage license too, just for the sake of it. So, and because it has everybody's address on it. So, but the point is, I was just worried about whether or not the stamp or the crushing the paper thing, whatever you call that, are equivalent. And they essentially are, right? Okay. I'm fine then. I'll stop having a heart attack about whether I'm screwing something
There
up.
are only 3 more slides, and I'm happy to share those again.
Thank you, Representative Reckett. And if you could go back to sharing the screen, Secretary Bellows, with those. Thank you.
So there was a unanimous recommendation from the working group that all notarial officers should be permitted to perform a notarial act with respect to an electronic record. Qualifications of a notary public, again, there was unanimous agreement upon the qualifications for notaries public. Relona is largely aligned with the current qualifications under Maine law set forth in Title V. The one exception being that Maine does not require a surety bond for notaries public. That is in Relona, and the unanimous working group recommendation was that it not be required. Length of commission. So the majority recommendation was to adopt a 4-year notary public commission. Relona leaves the length of the commission up to the states. We did some research. 31 states have 4-year terms for notaries public. Maine's current commission length, like Massachusetts, is 7 years. 2 working group members advocated for a 5-year commission, making the point that New Hampshire and Connecticut have 5-year commissions. A majority of the working group recommended 4 years. Database of notaries public, a unanimous recommendation that any notarial officer seeking to perform remote and online notarization be required to notify the Secretary of State, who should maintain a database of that information online. And of course, we already keep notaries public records online, so this would require some modification, but is very doable for us. Prohibited acts. The majority recommendation is to adopt all of the Rolona recommendations with regards to prohibited acts, including requirements for advertising disclaimers. One departure from Rolona is a unanimous recommendation from the working group to bring in enforcement provisions of current Maine statute to provide for consumer protection in the event of a fraudulent or improper notarial act. Maine has very strong existing protections for consumers in this area that we wanted to bring into the legislation and is included in the legislation that we've provided to you in draft form. And then the last piece is performance of marriages. And Representative Galgay-Reckitt already talked about how she, as a notary, performs many marriages. Currently, Maine is one of only 3 states that gives notaries public the authority to perform marriages. That's in Title 19 rather than the law on notaries public. A recommendation from the Department of the Secretary of State is the creation of a separate commission as a marriage officiant or celebrant. That would have the benefit of allowing people to register with the state to perform marriages and receive, the proper guidance on how to do that without having to learn all of the requirements for all notaries public. It would also allow notaries public to opt out of performing marriages. And one thought we might had was perhaps all current notaries public could be extended this additional commission free of charge for a term. But we just wanted to share this at this time, that this is a recommendation of the Secretary of State. That said, because no other states are performing marriages, Rolona is silent on this. So should you decide to go down this road, additional language would be required. In conclusion to the presentation, we do recommend that the Joint Standing Committee on Judiciary adopt Rolona with the modifications recommended by the majority of the working group members. And I will stop there, and I'm happy to answer questions on this PowerPoint, which is an extremely condensed version of the report, which is in turn the highlights of the legislation, which is very detailed. And I do want to thank every member of the working group. A tremendous amount of work went into those 8 meetings, and people were really engaged and really worked through the issues at hand.
Thank you very much, Senator. Old habits are hard to break. Secretary Bellows. I will open it up for questions from committee members, but remembering that we will, if we move forward with this, have a public hearing and a work session. But I do have one question just about the formatting in Appendix 3. Most of the language is the Rolona language, I assume, what you're proposing, even with some modifications. But on the last page of Appendix 3, you have some underlined language. Is that because we need to amend existing statutes as well? Is that why that appears in underlined fashion? And I'm seeing Kathy nodding her head yes. Okay. Just wanted to confirm that. Thank you. Are there questions from committee members for Secretary Bellows or any members of her team who are with us today? If so, raise your electronic hand. I think the fact that we have so many day-long meetings these days, at the end of the day, hands are not as quick to go up, but that's okay. Senator Carney,
Thank you. Thank you for your report, Secretary Bellows, and especially for the proposed legislation. I have a quick question about the proposed legislation. Do you have a version of it that tracks what are the main specific additions that are proposed to modify Rolona, so that we could look through it and see what's Rolona and what's unique to Maine?
So we could potentially, so we started with Rolona and we did track changes, but one of the things that we did as a favor to Oprah and the analysts, recognizing your short time frame, is we then took this and renumbered it in accordance with Maine law. So we did do so it wouldn't, we could definitely provide to the committee as backup information a tracked changes version of the original Rolona, but it's not presented in language that, or it's not presented in a format that works well for OPLA for purposes of Maine statute, if that makes sense. So, or alternatively, if it is helpful, we could walk down through, or perhaps I could prepare this for if you're moving forward with legislation, we could have our testimony track the legislation to specifically walk through the legislation section by section to show people where the differences are. That would be easy to do. Or alternatively, maybe we could create use comments to show people where those differences are.
Okay. If whatever is sort of the easiest and most efficient way for you to present the information would be helpful. I don't want to create extra work. I was mostly curious to see specifically what the main modifications were as compared to Rolona.
One of the things that I think is important also is you will see on the last page of your report, there's a list of repeals. So Maine's notary public law is not well organized. It's been established over time in different areas of the statute. So we did a very comprehensive and thorough review of all of the existing areas that we could find in statute that touch on notaries public. And so what we're proposing is a uniform law that would be its own in its own section in statute, and that it would repeal Title IV, Chapter 19, Title IV, Chapter 22, Title IV, Section 1056, and Title V, Section 82. So I just also want to share that, you know, when, for example, we say the qualifications of the notaries are substantially the same, the verbiage in Maine statute might not seem as simple as just being like, oh, here are the qualifications here and here are the qualifications here. That may be a poor example, but we will do our best to very carefully show you where that is. So
thank you. And yeah, thanks for your extensive work. It's an incredible work product.
Thank you, Senator Carney. And just a question, Secretary Bellows, where would this be located if we move forward with proposal and adoption?
My understanding is that we would want to put it where the current notary statute is. And I believe we had discussed putting it in Title IV. Is that right, Director Bodwin? Okay. That's a great question for your analyst.
and that's why our analyst, her hand flew up immediately when I posed the question. Peggy, do you have anything to add?
Thank you. Just real quick, I really appreciate the work that everybody did to put this into kind of standard Maine language. It was really, really helpful. And I will be, and yes, we had a discussion about where it should go and agreed that Title IV was the best place for it. And I will be happy to work with Ms. Bodwin and Ms. Flynn and Secretary of State Bellows to put together a comparison so you can see how the law would be changing and also how it compares with the Uniform Act. So we can all work together to put together something that will kind of answer those questions. So you know where Maine is unique and where it's kind of retaining its uniqueness.
Thank you very much, Peggy. That will be very helpful to the committee. Representative Moriarty.
Thank you, Mr. Chair. Will this be a committee bill or a departmental bill?
That's a good question.
Yeah,
Peggy?
so LD 1399, which became Public Law Chapter 337.
Is that the one sponsored last session?
Well, yeah, a whole bunch of people sponsored notary bills last year, and the one that went through kind of consolidated them, enacted the what was really the executive order about remote notarization into statute until this bill can come into effect.
Okay.
And it also directed the Secretary of State to do this thorough study and come up with these recommendations and then give you the authority to report out a bill. So that's a long way to answer your question. This will be a committee bill that will be referred back to committee, and you can have a public hearing. I'm assuming you'll hold a public hearing on it.
Okay.
What you might want to talk about, though, is whether you include the language about, I don't remember if it's in there, about performing marriage ceremonies, right?
That was what I was just going to say. That language has not been included here because it is a departure from Rolona. So if you decided you wanted us to draft language, we at the department would be very willing to draft that language. But it is outside of Rolona. It's just something that we know a lot of people apply to be notaries public because they want to marry people, not recognizing the other responsibilities that come with that commission. But we also recognize that a lot of notaries public want to be marriage officiants. So we would want to include some sort of grandfathering so that folks like Representative Reckitt could continue to marry people and not have to reapply, at least not initially.
So just before you lose that thought, if you could think about whether you want to include that in the bill before you leave your meeting today, I would appreciate that, because we can amend that title to make sure it's not just Rolona, but it's also some other changes. But I will try to pin you down before you leave this meeting today. Thank you.
And the other one thing that wasn't included here, but in consultation with staff about the requirements on the department for this new program, the current framework for remote notarization, that 1399 extended, it was basically the emergency order, expires on January 1st, 2023. And particularly the real estate industry has told us there needs to be a continuity between, there can't be a gap where remote and online notarizations are not permitted. Our department would request that there also be perhaps an amendment that would extend the current system up to June 1st, 2023, or July 1st, 2023, to just give us a little bit of extra time, perhaps a full year, to be able to make sure that the online database is ready, that we've issued rules, particularly around security and authorized electronic systems. So.
Thank you. And I'm turning back now to committee members for questions. Representative Galgay-Reckitt, you had your hand up first. Are you no longer have a question?
Well, I have been searching for what the qualifications were, and I finally found them. And so I took my hand down.
Thank you.
And it's not in the law, though. I think it's in the opening part of the letter. Or it's in the letter, but it's not in the Rolona text that I could find anyway. But I found it on the page 4 of your 3 of the letter. So if it's not in Rolona,
it's under section 21 is
okay.
The qualifications for a notary public are under section 21.
Oh, yes, thank you. Sorry, I had missed, I was like madly looking through it, trying to find it. See if I'd have to throw myself out, at the same time. So, thank you.
Thank you, Representative Reckett. Representative Libby.
Thank you, Mr. Chair. Thank you for being here today, Secretary Bellows. My question is, I understand that the consensus was from the working group that the legislation should include all forms of notarization, and I'm particularly interested in the paper remote online notarization. Can you please explain the implications of including the paper remote online notarization in the context of ballot harvesting in Maine?
So actually, that is one exception that the majority of the working group recommended be maintained. So, right, if you flip to the legislation and you see it's on the section 4, authority to perform notarial act. And you will see direct initiatives and people's veto referendums. So a notarial officer may not administer an oath. Well, that's the requirement for that you conflict of interest around referendums. There was one working group member who disagreed with that. But I believe we also, in notarial acts, prohibited electronic or remote notarization for elections. And that language, sorry, this bill is very, very long, by necessity, is also in. And Director Bowden or Deputy Flynn, if you find it first, please feel free to speak up.
Section 16B.
Thank you. Yep. So the notarial acts prohibited. So it says, notwithstanding any other provision of this act, a notarial officer may not perform the following notarial acts for a remotely located individual. That includes solemnizing a marriage, witnessing the marking and sealing of an absentee ballot, administering an oath or affirmation for a candidate for office or for a candidate petition, or witnessing the signing of an application for people's veto referendum or direct initiative, or administering oath or affirmation to the circulator of such.
Wonderful. Thank you.
Thank you, Representative Libby. Thank you for your response. Secretary Bellows. Senator Sanborn.
Yeah, I think I know the answer to this, but I just wanted to make sure that attorneys would still be able to perform marriages. And I don't think this upsets that, but I just wanted to clarify that piece.
We can triple check that for purposes of, but my understanding is that yes.
Okay.
Are there additional questions from committee members for Secretary Bellows? I am not seeing any. So again, Secretary Bellows, thank you very much for all of your work on this and for spending this late afternoon with us. Greatly appreciated. So at this point, I would ask if there is somebody who would like to make a motion regarding reporting out legislation, making sure that we, I know Peggy will not tell us what to do, but she might tell us if we're not doing enough in the motion. And I don't know, maybe, well, I'll turn to Senator Sanborn. I saw your hand go up.
Sure, I can try and make the motion, which is I move that the committee report out a bill based on the recommendations of the working group, and that we also include a provision for authorizing a authorization to solemnize the marriage or a marriage officiant provision in the bill.
Thank you. We have a motion. Do I have a second? Seconded by Representative Sheehan. So we have a motion and a second. I would now open it up to discussion from committee members. And Representative Reckitt.
Just quickly, I need a clarification of something that Senator Sanborn said in her motion. It was not clear to me whether you wanted the ability to officiate marriages to be in this proposed law or just the provision that a separate section could be set up to, a separate position should be set up to enable that. So I don't know which way you were, whether you were incorporating it in or adding it on.
Senator Sanborn, go ahead.
My understanding, but I'm looking to Secretary Bellows and others, was that it would add an additional section to the legislation, but not to Rolona, that would provide for the creation of a marriage officiant commission that would allow the person to officiate marriages. It wouldn't upset the ability of attorneys to also solemnize marriages because that wouldn't be an issue. But if you're a notary public, my understanding is it's not typical to be able to solemnize marriages just based on that notary public commission, and that was the recommendation of the working group, that piece of Maine's idiosyncrasy be removed. But I may have not followed that correctly.
Is there somebody in a position to respond to that uncertainty? I don't know if it's
Senator Sanborn just captured it accurately. And I think what we could do is create an additional amendment that would be rightfully in Title 19A, which is the Vital Records statute. And Vital Records has already said that they are amenable to this. The Office of the Attorney General was very much involved in this bill drafting as well. And on the working group, participated in the working group meetings, although not as a voting member. So we could easily put together some language to modify that section and also reflect it may be unallocated language that anyone with an existing notary commission as of the date of passage of the law be extended automatically the marriage officiant commission, so that we're not taking something away from people who may not be watching what's happening in Augusta, but that they're getting extended that commission, at least for the length of the term. And then when they would renew, we would ask them, do you want to renew as a marriage officiant or a notary public or both? But what our team has found through experience is that oftentimes there are people who want to be notaries public, but not necessarily perform marriages. And then there are people who want to perform marriages, and that's why they apply for the notaries public commission, but have no intention of doing real estate transactions or other actions.
Thank you.
Thank you, Secretary Bellows. Representative Moriarty.
Thank you, Mr. Chair. On the issue of the authority of an attorney, over the years, I've seen multiple documents, and at the point at which a notary signs, below the line, you typically see the words notary public / attorney at law. And I have always circled the one that was appropriate for me, having been told early on that an attorney can do anything that a notary can do. So is that, Secretary, your understanding, and do you intend to preserve that ability on the part of attorneys?
Yes, the legislation before you preserves all of the same rights and powers and privileges of notaries public for attorneys. And that is explicit in the law. And then similarly to Senator Sanborn's earlier question, it's actually Title 19A that explicitly makes clear the power of attorneys, justices and judges and notaries public, as well as clerics, to perform marriages. So that wouldn't change. This legislation does not diminish or change the power of attorneys at law in any way, shape, or form.
Okay.
That was something that was really important to the working group.
Sure.
I highlighted that there was a little bit of dissent. There was one person who thought that perhaps, but that is highlighted in my report. But the legislation that we have proposed to you reflects the majority, which preserves and retains all the rights and privileges of notarial acts for attorneys at law.
Okay. And as a quick follow-up, if a non-attorney applies to become a notary, I take it that that applicant doesn't need to specify a reason why they want to be a notary.
No.
From that point forward, it's their decision whether or not to do weddings, for example, and nobody really has any control over that other than the person themselves. No, they're not. They don't need a special rider saying that yes, you can do weddings too.
So one of the other reasons the department recommends the separate commission, which is contained in Senator Sanborn's motion, is actually the rules around performance of marriages do differ from some of the rules around other notarial acts. They're governed by vital records, and the requirements for a marriage certificate, for example, and the documentation around the marriage are governed by Title 19A and vital records. And so one of the concerns that we have is sometimes there's some confusion about that. But in terms of who chooses to do that, we're not suggesting, I mean, if you are an applicant and you meet the qualifications, we are not going beyond that and probing into people's motivations or qualifications, as long as they meet the qualifications under the law and complete the application and any required training. If you had a separate commission, then we would work with vital records to have a separate training that was very specific, and that might improve, some of the kind of common confusions and things that arise sometimes because of that.
Okay, thank you.
Tom, yeah.
Thank you, Representative Moriarty. Representative Rickett, your hand is up.
Yeah, I just wanted to, and I think that most of you are too young to remember this, but when I became, I didn't start out as a notary. I started out as a justice of the peace, which I started to do for the express purpose of being able to do marriages. And then when you eliminated the justice of the peace category, you made all of us notaries. And so that's how I became a notary, was by that route. So, and I can't even remember what year that was, but it was a long time ago. And I suspect many of you in this viewing here were not around when that happened. I have no idea what year it was now, but it was a long time ago at this point. So I'll be quiet now, but I just thought that, some folks might want to, Representative Moriarty is always bringing up history. I thought I'd bring up the history of justices of the peace in Maine. Thanks.
Thank you, Representative Rickett. And I am not seeing any other hands for discussion on the motion and the second, but before I turn to asking for a roll call, I do need to ask Peggy, do you have the guidance? Does this motion provide you with the guidance you were looking for?
I think it does. I think what you've said is the recommendations that are contained in the report, plus authorization to officiate at marriages without having to be a notary. So, yep, and I'm counting on Secretary Bellows to provide some language for that, and we'll slip that into the bill before it gets printed.
Thank you. With that, seeing no further discussion, I would call on our committee clerk, Supi Panett, to please call the roll.
Thank you, Mr. Chair. Are we okay with non-members on the screen?
We can move them out if you're more
Oh,
comfortable.
no, I just want to bring it to your attention. I'm fine.
It's okay with me. They'd be in the room if we were in a room, so.
Oh, it's always nice to have guests. So thank you, Mr. Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage. Representative Galgay-Reckitt.
Yes, with a tinge of sadness.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. I will recall the absentees. Senator Kime. Senator Kime is absent. Representative Babbage. Representative Babbage is absent. Representative Hagan. Representative Hagan is absent. Representative Thorne. Representative Thorne is absent. Mr. Chair, I have 8 members voting in the affirmative, 2 members voting in the negative, and 4 members are absent. That is the vote of the committee.
Thank you very much, Supi, for taking the role and reporting the results. As much as I know you like to have guests, I think we can move our guests back out of the panelist status, but thank you very much for being here and presenting to the committee this afternoon.
Thank you.
And with that, I believe that wraps up our work for today. I will turn to our committee clerk and our analysts to see if they have anything to add, and then I have an announcement to make as well. Peggy, nothing?
I have nothing. Sorry.
That's quite all right.
I do not have anything, Mr. Chair.
Thank you. Any committee members? Seeing none, I want to let you know that I just learned that there will be a delayed start to the state offices being open tomorrow. At this point, the plan is to delay that start until 11 a.m., which means we will not be able to begin our committee work until 11 a.m. If anything changes in that regard, if it's extended, we will let you know as soon as possible. But at this point, that's all the information I have. So we will see each other hopefully at 11 o'clock tomorrow and try to figure out how to get in all that work we have on our calendar for the day. And I see a couple of hands up. I'll start with Senator Carney and then Senator Sanborn.
Thank you, Chair Harnett. I just wanted to sort of ask and kind of confirm, it's my assumption that if we're starting at 11, we are going to work through as much of our agenda as possible tomorrow. And I'm just wondering if that is your assumption as well.
That is my assumption, and I don't know exactly what that means. I don't know, and maybe I'll ask Peggy, should we put off, say, the FOA reviews to focus on the public hearings that we had scheduled? Or is that something that we should discuss when we get offline?
Well, I'm just trying to think when we would reschedule those for the other committees. And actually, you have one of the committees here with you. You can, if you can add that another day, that might be fine. The other committee is Health and Human Services, and I know they'll be diving into budget beginning at 9:30 on Monday. So I also realize that you need to get those public hearings in, and you don't want to inconvenience people who think they're coming for a 10 o'clock hearing and it doesn't start till 11. So if you're going to put off anything, probably the freedom of access reviews makes sense.
Senator Sanborn, I know that you have one or more of the.
Yeah.
I have 2, I think, and I was just gonna offer that I can do that easily at some other point tagged on to, even the end of our work. I'm frequently with you at the end of the day. So could potentially do it then, because it generally just requires the committee to be present and not any input from anyone outside of the committee and me, which is also the committee. So it could be useful to put it in like language review, at some other point after we complete our work for a day.
Thank you. I think that's best. Senator Carney, do you have concerns with that approach?
I think that's a really great way to handle it. I do think maybe we could start with the HHS though, since they'll be diving into their budget stuff. And I think doing one efficiently is a good way to start our day. And then we could dive into our public hearings.
Okay. Sounds like a plan to me. Peggy, is that okay with you?
That is perfectly fine. I will double check that Senator Claxton and also DHHS are available because it's a bill that the department has recommended.
And can you tell me the bill number on that?
Yep, it's LD 1849, and it is about information that right now accrediting organizations provide back to hospitals as they do kind of an evaluation and a survey and a record of deficiencies and plans for correction. Right now, that information is not provided to the department. DHHS would like that information and they want to get it from the hospital and then they would keep it confidential. So, you know, you might want to discuss that, but that's what that bill is about. That's what you will be looking at tomorrow.
Thank you.
Now,
So,
the department doesn't get that information.
okay, thank you. So that we will do the FOA review on LD 1849 and then flow right into our public hearings.
Great.
Okay. And if there are any changes, we'll get in touch with everybody as soon as possible. Thank you all for your efforts today. It was 65 degrees or 68 degrees when I left here yesterday, and now we're talking about a snowstorm. It's pretty remarkable.
So it goes.
So it goes. So with that, we will meet again at 11 o'clock tomorrow morning. Thank you all.
All right. Take care.
Thanks.